Yeah, it did, yeah. That was me too. That's why Jim was here.
In person, just kind of like, it's the news of the content.
Well, he's very honest to me.
So,
Yeah.
I heard me almost an hour.
Where is it? From where you are to get here?
About 4.5 hours.
Yeah.
It's about as
Probably
far as
fine.
it can be, yeah.
Yeah.
It's still made.
We have some townships that are way down there.
Yeah.
You know, close to the border,
Yeah. Whenever
the Union.
I
But
talk to somebody from out of state, I'm like, wow, South
So
Dakota.
did anybody call Steve on his,
We live in a little square.
scheduled meeting to the Florida Keys?
That they emailed him and said, which beach, which golf resort can you get service at?
I'm gonna say I spoke with him twice during the session when I was out here, and he never mentioned anything about a long-standing meeting that he could not avoid in Florida.
Home Beach Street.
it's kind of very much everything is 2 hours.
Yeah.
It's a good central location. Okay.
Yeah. But a lot of people just,
I mean, Kate.
yeah.
Okay. Yeah.
References around that.
Understanding.
Practices and-
Yeah. I went to that training also, probably my first year on the job with this. And I thought, okay, one of my directors invited me to go and I thought, I'll sit through. Very informational. And little did I know how important it would be to kind of have that understanding in the background of those requirements and that, you know, how everything is kind of viewed and
Yeah.
a lot. I should probably take it again.
Good morning.
Figures.
It was a great one. Environmentally conscious and a lot of
Mhm.
people that tend to be on the kind of more regulation on the cable
Yeah.
side. You know,
Yeah.
it's like the great management.
So to get into that, nice to see you in person. Yeah, yeah, not a bad drive.
Are when there are some failures.
Well, yeah,
I was
No, no.
surprised. I
Well,
didn't
that's
even
good
agree
contact.
yesterday, and he didn't have nearly the snow that I was expecting.
no, we ended up, I mean, I think we probably, I was gone all, the whole last weekend, but
There's a lot of.
we probably got around 10-ish inches, I want to
That
say.
medium definition.
But it was melting as it
And
was.
I was gonna say, you must have been
9
really warm
later.
prior, because I was really surprised. I was expecting a lot more snow,
Yeah,
and
so was I. I mean, there was, I got
It's a lot bigger.
There was
The other thing.
time, I mean, I'd say the most there was actually piled up was probably 6 inches.
Is
And
it seems like there
came on
is
the back deck.
full almost, and that if you apply at this level, you don't need to advertise
Yeah.
when you expand.
You know, so it cleared up.
yeah, Hecla still probably had a good 6, 8 inches sitting on the ground when I went through mid-morning,
That satisfies the notification. I'm like,
right at lunchtime, and the ground was large and clear.
the operators, that's a great thing, but it's not.
Every time I looked at the radar, I knew I had that trip planned.
Yep.
And I'm like,
Well, we'll take the void.
oh, yeah.
Man, it was dry. It still is, to be honest with you. Some more. I'll take rain instead of snow though.
That's always the factor that, but we got legislation passed this year.
Yeah.
You know, to be able to partially address that. At least that's a foot in the door to start addressing it.
Were you guys excited about the refunding monies? Boy, that was one that we really fought for down in
Last week, or supposed to spend the other day.
Senator Davis,
Stuff that came through, was it Wednesday? I think it was around Wednesday.
we have so much
Wednesday,
appreciation.
Thursday, Wednesday.
Last year,
Came in
it
late
kind of got
Wednesday.
run through the mill.
But it did.
And, I got Andrew and started.
Position. And then this year, she.
And then the next morning, I got a call, my buddy gets involved, he's trying to get up to Fargo to see the grandma before she passed.
That's
He said,
next thing,
Then we'll
bringing up
always
that session is looking for.
but then as soon as he got past police garbage, it was terrible. He turned around, Toronto, that's the one.
Okay,
That one, I should start over.
I'm gonna just start at the beginning again. Michael Smith,
Present.
Austin Hoffman,
Present.
Carla Engel,
Present.
Kristen Jasper,
Present.
Tracy Kelly,
Present.
Dylan Kirchmeyer,
Here.
Dave Borderick.
Present.
Steve Willard, Jane Roth,
Here.
Garrett Bischoff, Jeffrey Gray Loeb,
Here.
Cole Heisey, Kellen Willard, Terry Slutton,
Here.
Jim Urban.
Here.
And one.
Thank you. Before we get going with the agenda, the next agenda item is, I suppose, the public comment period. Public comment will be limited to 10 minutes per. Is there anyone present in the room who would like to make public comment at this time? Okay, hearing none, is there anyone online who would like to make a public comment at this time?
Hello, this is Gary Kaufman. I'm on the phone. Can you hear me?
Yes, sir, we can.
Hello, sir. Again, this is Gary Kaufman. I appreciate the opportunity to speak to the task force. I'm an attorney from Huron, and I've worked with the open meetings laws for almost 40 years. I've represented school districts for over 25 years and served as Huron City Council or City Commission attorney for 10 years before becoming general counsel for the School Board Association. And while at ASBSD, I worked extensively with Mr. Bordewick, who's on the task force, Steve Blair of the Attorney General's office, who used to assist the Open Meetings Commission, and with others in putting together the AG's Open Meetings brochure. And I have several comments and general comments, and then some specific comments regarding what's on your agenda today. And I will try to be very cognizant, definitely, of the time. On general comments, I'm wondering whether or not the task force has considered having written minutes of its meeting. I would submit it'd be a good idea for there to be written meeting minutes so people who are not at the meeting could read what the task force had done without having to listen to the audio recording. Second, I know that at your November meeting, the task force did not make a recommendation to the AG regarding the discontinuation of the new merit filings abstract. It's my understanding is going to forward the idea to the Attorney General. I'm just wondering about the future of the abstracts, both currently still online, and whether we will be receiving updated abstracts, which I hope is the case, because I found those abstracts to be very informative and helpful. And also, with respect to the November 25 task force meeting, 2 of the 7 proposals did not identify the source of the proposal, or 2 did and 5 did not. And none of the draft revisions on today's agenda identify the source of the proposed revision. And I would submit it might be a good idea for the task force to consider identifying for the public the origin and source of the proposed revisions. As it relates to specific proposed to draft revisions, 2 that I specifically want to reference. First one is item 4E, which is number 10, creating clarification on the public comment process. And SDCL 1-25-1 starts by saying an official meeting of a public body is open to the public. And again, recent amendments have required governing boards to allow public input, and I fully support the current statute. However, is this draft proposal a solution looking for a problem? Is there a problem with the current law? And if so, what is it? Where is it? Is it statewide, or is it isolated to a very limited number of situations in a very limited number of state agencies or political subdivisions? I would ask the task force to keep in mind when considering this proposal, there's a big difference between governmental meetings, which are open to the public, which is the cornerstone of the public meetings laws, commonly called sunshine laws, as found in SDCL 125 on one hand, and public meetings where the governing body receives substantial input from the public, with those types of public meetings often referred to in statute as public hearings. The public, of course, can always reach out to their elected officials before or after the meeting of the governmental body. To me, the question is how much time during the meeting of the government body, when it's to do governmental business, must be devoted to public input. This proposal would require time for public input on each individual item, including each individual consent agenda item, before the governmental body could even discuss that agenda item. Now, I'd ask you to think about this proposal in relationship to today's task force agenda. If this proposal became law, and if the task force was a governing body of a political subdivision subject to 125, then there would have to be a public comment before the very first thing on your agenda, the call to order and roll call, and then another public comment before the agenda approval item, and then separate additional public comment periods before the task force discussed each of the 5 individual proposed draft revisions. Task force has set a 10-minute max for each speaker during the public comment period. If there are 2 speakers for each of the just noted 7 task force agenda items, and those 2 speakers each spoke for 10 minutes, that's 140 minutes, over 2 hours, would be added to the length of your meeting today without the task force actually having discussed anything on its agenda. I understand that the proposed agenda says the governing body may establish reasonable limits on the time allowed and for the total time allowed. But I submit the term reasonable is ambiguous and problematic, especially as this proposal requires specific time to be set apart for public input before each individual item was discussed by the governing board. I actually went online and looked at some public school board, municipal governing board, and county commission agendas to get an idea of the number of items commonly on their agendas. I did not include exec session items, although arguably the public comment period on the proposal would apply to executive session items as well. And based upon the proposal's wording, I did include separately consent items. I looked at 2 different public school boards. One board had 15 agenda items, the other 32. I looked at 2 municipal governing boards. One had 38 agenda items, the other 19. I looked at 2 county commission agendas. One county commission agenda had 36 items, the other 18. Out of those agendas, the minimum number of agenda items was 10. If there was a 10-minute total time for public discussion on each item, and there are 15 agenda items, and if the full 10-minute public comment time for each item was filled with public comments, that would add 2.5 hours to the length of the meeting of that governing body, again, without that governing body having actually decided whatever it was that was on the agenda related to that issue. Public participation is extremely important to our representative democracy, but we elect people to represent us. The people may provide input to elected officials outside of the scope of the governmental meetings, before and after. I would respectfully ask that you don't let the concept of public input during state agency and public subdivision meetings become the overriding concept of the open meetings laws by having public input outweigh the importance and significance of the public's right to observe, watch, and listen to the governing body do its work. If this proposal was to become law, a 2-hour county commission or city council meeting or school board meeting could very easily become a 4-hour meeting or longer. And then the second agenda item on the task force's agenda that I'd like to briefly discuss is agenda item 4B, which was the table number 7. New law about clarification official action must be preceded by a motion and vote. According to this proposal, there's not even a requirement there be a second to the motion or a discussion on the motion before there's a vote. I think that would significantly change how most, if not all, governing bodies do things now. Most, if not all, follow the procedure of first there's a motion, then there's a second to the motion, and then discussion, and then a vote. And the other thing about this proposal that I'll comment on is that it's one thing to avoid an official action if there was no motion or vote, but this proposal would make a violation a criminal offense. And I would submit that's way, way too extreme. And who's the state's attorney going to charge with a criminal offense if there was a violation alleged against a 5-member municipal governing board, a county commission, or public school board? Would it be the chair or the president of the governing board, or all 5 governing board members? So I think there are significant issues with that item. Recognize my time's up. I definitely could talk longer on other issues, but I'll stop with that and I'll stand by if there's any questions. Thank you.
Thank you, Mr. Kaufman. Any other public comment at this time? Online? Okay, hearing no other public comment, at this time, we'll move into adopting the agenda. Any additions or changes to the proposed agenda? Hearing none, I get a motion on the proposed agenda.
Hoffman so moves.
Second.
I see.
Motion and a second on that. Any further discussion? Hearing none, all those in favor say aye. Aye. Opposed?
aye,
Motion passes. We now have a final agenda. We'll now move into section 4 of this agenda. There are 1, 2, 3, 4, 5 different revisions or creations of new law to be considered by this body here today. Ms. Katz, intention, if it's all right with you, would be to just let you kind of introduce each one of these. I believe item 4A and 4B are both tabled from our November task force meeting, and 8, 9, and 10 are new to this task force. So let's move alphabetically. So we'll start with 4A, which is labeled as tabled number 5 from last November.
Okay, thank you. Beverly Katz. The table number 5 was delayed. We wanted to have another discussion on this statute that is SCCL 1-25-3. Previously, it said the state shall keep detailed minutes of the proceedings of all regular and special meetings. The minutes required in this section shall report and how each individual member voted on the motion on which the roll call is taken. And it shall be made available for inspection by the public. A violation is a class 2 misdemeanor. This task force board had suggested changing the word state to be all public bodies, subject to 125 1.1 and 125 1.3. The all-encompassing all public bodies let me think that, well, there must be something that addresses this already. So I pulled SDCL 7-10-1, where the county auditor keeps the record, SDCL 9-18-1.1, the city finance officer keeps the record, and SDCL 8-6-3, the township clerk keeps the record. Also in law, 127 1.17, draft minutes of the public meeting must be held pursuant to SDCL. All meetings pursuant to 125-1 are kept by law and shall be made available within 10 business days. So I put this information there so that this board can wrap their head around, is the public bodies something that we needed to change for all public bodies or leave it as just the state. And the other part of this change was to report the results of each vote taken by the public body. I think that just makes it more clear, reflecting the results, who was opposed and who was against. I think that is a summary of what we're.
Thank you. And with that, I'll open it up for discussion here by the task force as well.
Terry Sletton with the Association of Towns and Townships. I feel really strongly that because townships do already have laws that direct clerk minutes, the draft, those types of matters are already addressed. The second piece that would support that is the township boards are extremely small. There's 3 voting members on a township board, the clerk and the treasurer. So to put an additional burden and an additional requirement upon townships is excessive from our point of view.
I questioned the wording of all public bodies. I think I mentioned this at last time as well. I tried to do a little bit of legwork and looking at about 10 different sources of definition for public body. I mean, you can find everything from library boards to water districts, sanitary districts, your local volunteer fire departments. Obviously, I'm going to speak from a rural perspective. We have a hard enough time finding people to step up and fill roles without attaching criminal penalties to procedural errors. I just think that we might be overreaching a little bit. I can see the spirit of the law, but without being able to define it better to address where we're having perceived issues. The other thing is the ambiguity of the word detailed minutes. It's open. It's up to interpretation of the people at the time deciding whether what is detailed and what isn't. Now, we'd like to say use some common sense, but I think we can all agree that common sense isn't as common as it used to be, especially when it comes to lawsuits and litigation and accusations against people in a public position. It seems to be kind of in vogue to take your shots at people that are sitting behind a desk that are trying to serve public need as best as they can. So unless we can define detailed minutes and make this so that we're not going to be scaring people off of serving, I think we need to really reassess the language before proceeding forward with this legislation recommendation. I'm sorry, Jim Urban.
I see Neal County Commissioners, a question directed towards Beverly, who I assume is sponsor of this. Would this practically change anything? Is it more so for clarification? Is it already a class 2 misdemeanor if public body doesn't give detailed minutes?
To Beverly Cotts, to address where the source came from, this was the original Open Meetings Commission drafted handful of laws, revised them, and that's what we presented last time. So this was one from last time. So this is the source of that. I think your question was, is the violation the misdemeanor?
Yeah, as well as currently written.
Yeah, that is the way it is.
It only applies to the state.
Currently, it's only to the state. Yeah.
So my recollection, Michael Smith, my recollection as well from the Open Meetings Commission was SCCL 125-6, I believe it's found in a couple other places. The Open Meetings Commission only has jurisdiction over issues directly found in this chapter, meaning 125. So as Ms. Cotts alluded to, counties, cities, and townships all have the same requirement, but they're found outside of 125, meaning that when there is a potential or in violation, it falls outside the jurisdiction of the Open Meetings Commission, meaning really from my perspective, is that there's really no teeth to it. There really is no, there's no way forward, at least with the Open Meetings Commission, anyway, for a violation. So some of the intentionality between, by adding in this number 5 was bringing all public bodies into the requirement of keeping minutes, so that if there is right now it just applies to the state as far as the Open Meetings Commission is considered or is concerned. This just kind of opens up the door to allow a county to come in on another political subdivision that we currently don't have any jurisdiction.
So Austin Hoffman and Matt said ultimately exactly what I was planning on commenting here as well. What I would add to that is when you're looking at these other statutes, the 7-10-1 for county auditor keeps record, and go on to the city finance, township clerk. Those are already there, obviously, but again, not under the purview of the Open Meetings Commission. So if there would be a complaint, let's say there's a complaint against this city for not keeping minutes, the Open Meetings Commission would have no jurisdiction there to review that, to go over it and so forth. What I would like to see happen in a perfect world is move forward with the proposal that we have for number 5 or something similar to it. 1.1 and 1.3. 1.1 is the one that has the political subdivisions, which is really all of the boards that you're going to find that are making decisions for the public, I guess you could say. Instead of having these other statutes, ultimately just get rid of those and move them all into 1-25-3 so that it's the same thing, it's the same meaning. Still have to have minutes, they still have to be kept, but then at least the Open Meetings Commission has some authority there to review a complaint if there is one. I mean, that's really the way I'm looking at this. So I understand where your concern would be coming from there. Absolutely, there'd be a duality of statutes meaning the same thing. Which one are you going to go with? That causes some concerns, some possible issues. But I think if we move forward on number 5, in all reality, we probably should be getting rid of the other statutes pertaining to the county auditor, city finance, township, and so on, because they will be covered under the other one.
Those areas that you identified, the other forms of those that have to adhere to the open meeting laws, how many of those are paid like salary or position other than townships?
Are you at like other boards?
No, those that you listed that have their specific laws that direct how they take their minutes.
Okay, so that would like the county auditor, city finance. I mean, the county auditor is a paid position. City finance is, I would assume most places a paid position. Township clerk, that I don't know.
Well, let me help you.
Probably guess not many of them.
Right. And so Terry Slutton, there's a distinction to be made. Those who serve at the township level are sacrificial positions. They typically have a job outside of their clerk position. They also don't have a large group of individuals from which to fill those positions. Townships serve their local 36 square mile group of individuals. Typically, that's who they represent. So to put this level of mandate upon someone who has an 8 to 12 hour job separate from someone who is paid to do those duties as part of their job description is excessive.
Kirsten Jasper, can I make a quick comment? What if, how about that? What if instead of putting them under 125, within 125, we say minutes, the state is required to keep all minutes, and the county, municipalities, and townships, as required pursuant to, and just tie those statutes in, are subject to the open commissions or the open meetings commission or something for those purposes. Part of my concern, kind of to play off of what Terry was saying, is if we get rid of those statutes are in the county auditor chapter. They're in the municipality chapter. They're in the chapters where those individuals are going to go to look and see what they're required to do. To be fair, they're probably not going to look at 125 to see what their requirements are. And so if we keep them in the chapters where they know to go to look at what their obligations are, I think it's a safer bet that they will A, know about them, B, follow them. But if we tie them in or loop them into the commission, at least then there might be some more teeth availability if they don't follow the statutes as they currently stand.
Carla Engel, I want to echo what Kirsten just said. I totally agree. There is a very big difference between how state agencies operate. Very often they have an attorney at the table assisting them, ensuring that they're complying with the law, assisting them before the meeting to ensure that they're in compliance. I served on a school board for 9 years, and it was rare to ever have an attorney at the table. These are citizen boards, and I'm very concerned about making it so very difficult to serve on these boards and commissions. At the same time, I want them to be held accountable. So I really like Kirsten's suggestion, and that's kind of what I was thinking too. It could be very simple to simply add references to those other statutes to chapter 125. So there's some enforcement ability. People can make their complaints if you have a school board or another local entity that's not operating appropriately. But I'm just so concerned about creating traps for these local government entities that when you've served on them, you know, they are doing the hard work. They really are. And I think we need to protect that while at the same time protecting the public's ability. But I feel like this goes too far. This just goes too far.
Austin Hoffman, I just want to make sure, so the main concern, is the main concern here the possible criminal implications? Is that what your big issue there would be? And that's understandable. Myself and Matt have been on the Open Meetings Commission now for 2 years.
Sorry, Mike.
I've been saying Matt, I'm sorry, Mike.
It is.
Okay, fair.
Just over 2 years.
We haven't seen, and I'm not saying this is a reason why we should or shouldn't have criminal penalties there, but there's yet to be a criminal prosecution for any of those. If we're seeing them at the Open Meetings Commission level, that means that the local state's attorney decided not to file criminal charges. And that's why we're looking at it to see if there's something there that more or less needs to be put on a piece of paper that said, hey, you're not supposed to do this. Please do better in the future. We don't have, the Open Meetings Commission does not have criminal prosecution authority. It's very understandable that there's a concern there for, as you were saying, a township of, I mean, in some places, I know in McPherson County, there's townships that are probably less than 100 or 200 people. There's not many people there to begin with. Not many people you're going to want to find. It's going to be a lot harder if all of a sudden they're looking at possible criminal prosecution for not having the correct minutes put together. Certainly not opposed to the idea of somehow looping it into 1-25 while keeping the statutes as they are. Personally, from my point of view, I believe that there should be some kind of an oversight there from the Open Meetings Commission. That is the end goal that I'm looking at on this one. Whether there are criminal charges or not, frankly, not a huge concern of mine. I think if we can find that middle ground there, where we can tie it into the open meetings purview, especially for the township stuff, while keeping it, you know, there doesn't need to be a criminal penalty. If something that drastic happens in a township, you're probably looking at money going somewhere where it's not supposed to go. There's going to be separate criminal issues there anyway, you know, so that'd be understandable.
I'm sorry, go ahead.
Well, Jeffrey Graylow,
I wanted to just pose to Jim Irvin and Terry Slatton. So with your deeper understanding of the current way things run on the township level. So I've never been on a township board. So what's the current level of, you referenced the statute that minutes are required to be kept. So there is already in statute the requirement that minutes are kept and they're held by the township clerk. So is the only change the addition of the criminal penalty here, or are you reading other things in this proposed statute that would be a change?
I personally was not aware that the open meetings board wasn't able to review their allegations. So that to me, I think we've got that board. And we've got this instance, should it arise, they would follow together. I mean, it's, if there's problems at the local level and we've got an entity to review those problems, I don't see that being a major issue for most townships because we're trying to do it right. But what concerns me is the individuals that are going to use that as a tactic to tear down the board because they don't like the way something was done. And Terry can attest to this, was just telling me yesterday that she had a request going back 10 years of minutes, which we're going to address in another topic here. Great, thank you. But that's the kind of thing that I feel that we're seeing more and more of is people using the law as a weapon against public boards, which is really discouraging public participation in these boards and organizations is that threat. I also look at, a quick Google search, because I'm not a lawyer, what is a class 2 misdemeanor? And I view a minutes violation as a victimless crime for the most part. I mean, yes, we have the duty to keep the public informed, but there's really no harm when the minutes aren't as detailed as somebody thinks they should be. And we're putting a class 2 misdemeanor on them, which is at the same level of some other crimes that actually have defined, damages and criminality involved. I wish there was a class 3 misdemeanor. Maybe I'd be more on board with it. But with what we're working with, I just don't think one equates to the other in terms of crime and punishment.
Yeah, Jeffrey Greenwald, if I may. So I think that does make some sense to me, that the recording of the minutes might be a victimless crime, but it seems like one of the main goals of this whole task force and of the commission is the recognition that it can be a cloud that obscures something that is important and does have victims. So, if a township is a levying body, it's going to take people's resources and use them in a certain way. So someone could be harmed by those resources not being used appropriately. And having the minutes, it seems like one of the keys here is trying to always make sure that there is a bright light shown on things, that there is records kept, because without those records, then it becomes very hard to see sometimes if there was something that created a victim that occurred. If there was a body that was making decisions and they were doing it inappropriately, the whole purpose is to make sure that there's a lot of sunlight for the public to see what did occur and what didn't occur.
There's already statutes that say, the finances have to be kept openly read at annual meetings, open for review by the public. So what you're talking about is embezzlement, and like Austin suggested, there's already penalties and triggers in place to address those specific issues. We're adding a new lack of detail in minutes to the criminal part of that of the law, and I think it's overreaching and going to be discouraging public participation. When we already have laws to address the what ifs, let's not add more potential what ifs when they really don't classify it. Kind of my feelings on it, but I do agree. I don't want to skip off of this, but what defines detailed minutes? So when my neighbor's upset with me over something that we've done in my township and they want to get me in trouble and they go to my state's attorney and say, hey, their minutes are terrible. I read them. I can't make heads or tails of them. So we name a subject, we name, discussion on it, how it was motioned, how it was seconded. That to me is detailed. But if they don't take every comment and stuff made, is that detailed? I mean, I don't like the fact that it's an open-ended language on it that gets left up to interpretation.
Who's going to train these individuals. Clerks serve 1-year terms. Typically, they run for decades.
Most of them don't run, they get appointed, rotated back into the position.
But who's going to train these individuals to that level? We have just under 900 townships in the state.
Tracy Kelly, I completely agree with Austin's comments. I think that there needs to be some oversight by the Open Meeting Commission. I can tell you, I'm not in favor of the criminalization a lot of times. And I'm going to first and foremost apologize to the commission for sending lots of complaints your way. Because Austin's right, and I've been getting a ton of complaints. And I don't necessarily prosecute them because a lot of times what I am seeing, and they're very trivial issues, but the complaint that'll come into my office will be like, I want them prosecuted to the fullest extent of the law. It's a class 2 misdemeanor. And the complaining party is very adamant. And usually it's somebody that has a grudge against somebody on the board. And so I think trying to utilize my office and bring a criminal charge is an inappropriate means of doing that, unless it's something that, in my opinion, truly is criminal, like an embezzlement or something along those lines. But at the same time, I do think there needs to be transparency and accountability to the taxpayers. And I think, when we talk about detailed, and we're going to get to that later, I think one of the things that can help and alleviate some of the issues from the townships or even other boards are the idea of audio recording these. I mean, what better, what better, capture of what's actually being said or done in those meetings than the audio recording. And the idea of detailed is going to vary from one person to the next, and what advice they're getting from their legal counsel versus who they have on their board and is trained in understanding, here's what I need to keep, versus just somebody that's been pushed into the position and appointed, be just a warm body to serve that position. So I think it does need to tie into the Open Meeting Commission so that there can be some guidance and some oversight. But I don't like the idea of necessarily making it a criminal action for some of those.
Well, I see. There's been a lot of discussion about the criminal penalty. And I remember, I asked Beverly at the start of the meeting for discussion on this, whether it was already a violation in current statute. And I pulled it up here. It does already appear it is a class 2 misdemeanor as it stands. So we're not adding any criminal penalties that aren't already there. And I do like the idea of putting up these public bodies aren't currently under the umbrella or jurisdiction of the Open Meetings Committee, making them so. I understand the burdens, though, that this could impose on townships. I did want to bring up one idea, like in item number 8. It delineates between smaller public bodies and larger ones, specifically first-class municipalities and county commissions with a county the population exceeding 5,000. I'm not sure exactly how to go about it, but we could incorporate some language in this that would exempt or townships and other smaller bodies. Because I think we can, maybe all agree we should be bringing larger public bodies up currently into that purview of possible review and settling disputes.
If I may, Kirsten Jasper, just for a clarification, there is a change as number 5 is proposed with regard to the criminal penalties. And the change is the current criminal penalties only apply to the state. This change would broaden it to all public bodies. So not all public bodies fall within the criminal penalties put forth in 125.3, which is a distinction because that's where your townships, your municipalities end up falling within that criminal class 2 misdemeanor criminal provision. And I think, well, yes, there's already a criminal penalty potentially under 125.3 is only to the state. And so there is a change to that. And I don't want that lost. I'm not saying your idea might not resolve some of the issues, but I just wanted to clarify that aspect of what you were saying. Because we are changing 125.3's application from just the state, which if you look at 125.12, I think it is where it defines what state means and what public body means. And so those are two distinct terms and have different meanings as to who they apply to.
Jim Urban, if the goal of number 5 is to bring more, oversight to the open commissions meeting, why not make language changes to the other 3, 710, 918, and 86, so to that point? Let's put the language in those laws that make them to the oversight of the Open Meetings Commission for alleged violations without attaching the penalty and without detailed minutes and some of the other language that we're getting hung up on here. It seems to me it'd be easier just to add the one thing that we all seem to agree on to the existing laws instead of trying to recreate or redefine law.
Michael Smith, one of the concerns I have on that, as we've talked through this, is these 3 statutes specifically implicate counties, cities, and townships. We have sanitary boards and school districts. I'm not sure we did an all-encompassing review. There may be some other statutes out there, but there are a lot of political subdivisions which are public bodies that do not hold statutory requirements for minutes out. So by adding this language of all public bodies, that brings everyone in who is, that meets the definition of 125.12 as a political subdivision or a public body, which are the same thing. So the idea, I like the idea, but I don't know if it allows us to bring everyone in, and perhaps that's not the intention here, but I'm not aware, for instance, of a sanitary board, an equivalent meeting requirement statute that mandates that a sanitary board keep minutes in the same way that county, cities, and townships have to, as well as the state here in 125.
Kirsten Jasper, are we looking for that? Do we want, is that what the commission wants? I don't know, but we could we could leave 125.3 as it is, and then we could make a 125.3 point, whatever they decide to do at LRC, that says, for all other public bodies, please keep minutes as required by your law. If not required, minimally set a minimal standard for what they need to do and don't attach a criminal prosecution. It brings it in to the commission as far as being able to review whether you're doing your minutes as you're supposed to. It doesn't change the law as it currently exists as to those requirements necessarily, but it opens it up and we can set for all others that don't have a requirement. This is your minimal requirement you need to set forth. Kirsten, I'm just spitballing. I'm not saying this is a great idea, but at a minimum, you set forth the results of each vote taken by the public body. And if it had to be roll call, we get everybody's, right? The minimal standard, if that's what we want it to be, that can be the statute. It's a separate one. It reads separately, has separate implications, but then it also follows the structure, I've talked a lot, of 125, where we separate out the distinction between the state and public bodies. There's a reason it was distinguished at the beginning. Why would we not recognize it now? And I think part of it is for the issues raised. Public bodies, they don't always get your paid employees and their attorneys.
Yeah.
In the answer, Jim Urban, if the intent is to create that last avenue for the complaint to be heard, the state's attorneys aren't willing to take it on at the local level. The claimant wants further, another pound of flesh or an opportunity. This addresses that. I mean, we can give in those other statutes the ability to have the complaints heard at the state level without attaching it. It should be a fairly benign sell to our association membership. Not sure how the fire departments are going to feel about it when that law comes through, if it does but I can see the need for that as well. I mean, we're dealing with public dollars and in some cases influencing public policy, so we should be held accountable. But at the same time, we're also talking about 10 guys in a community of 300 people that take the time to step up, or guys and women, I'm sorry, that are willing to give a lot of their free time, and to take it to this level. I think you're just discouraging participation in an area that it's already hard to find participation. But I think, Terry, I don't know I don't want to speak for our association, but I think that if we were to do what Kristen said, attach the language to those other statutes that brings it into the open meeting board without attaching the criminal penalties to it. I think a $500 fine is probably less of a penalty than the embarrassment of having your name put in the paper for an open meeting law violation by the state. So I think the deterrence there without the criminal charges being on your record when you go for your next job interview.
Austin Hoffman, just a little background here, and Mike, not Matt, feel free to correct me on this if I might have some of my facts incorrectly remembered, but in my mind, one of the issues that the board saw where this stemmed from was a water board out in the hills, actually, and they were getting a loan for several $100,000, if I remember correctly. They were not required to take minutes. There was nothing on paper that said which of the board members voted for or against it. They more or less met kind of in a back alley deal, and they apparently decided to sign off on the loan. That's all taxpayer money, and that's a lot of taxpayer money for the size of area that the water board had control over. So at the end of the day, the criminal side of it, you know, if that water board would have decided to all of a sudden put that cash in their back pocket, like I said before, there's other penalties there. I'm not really concerned about the criminal side of it, but we have to be able to hold, regardless of what level of public officials this is at. The main thing here is at some kind of accountability, and I think being able to move that over so that we can review these on the, the board can review them at the end of the day is really what we're looking for. As far as fire departments go, understand the concern there. I'm on 2 local volunteer fire departments. We take better meeting minutes than most boards do for one reason or other. So I mean, maybe some places.
Most of us
Well,
on board.
Yeah. So I mean, I think it's not, I know there's a perception, talking about training earlier, I understand that. There's a concern there of who's going to teach people how to correctly take minutes. Most of the time, it's just writing down some notes of what was talked about, what was done, whether it was a yes or a no. If it's a roll call, you write the names down, who voted for and against it. I mean, we're not looking for second by second who said what, really just what decisions were made, whether it was a yes or a no. If it was roll call, who voted yes, who voted no. So I don't think it's that much of a learning curve. Most places are probably already doing that. It's just that there's nothing giving us oversight if somebody's not doing it, and they should be. And when issues like that come up with that water board I was talking about, there was a lot of he said, she said back and forth in that meeting. And frankly, I'm still not positive if we know exactly what did or didn't happen, but having some minutes there would have made it a lot easier.
Is it time for us to, offer a vote on, your suggestion? Or is there more time for discussion?
Well, I
Because
think,
I'm very satisfied with that suggestion.
ultimately, I mean, at any time, feel free, somebody can make a motion. There was some, what we're discussing here, I believe, is a potential motion would be essentially the creation of 125 3.1.
Right.
I'm not sure if the room then feels a need to have a discussion about the word detailed, which already exists inside of 125.3. Do we need to have a further discussion on that word detailed?
Jeffrey Graylow, have the courts had discussions about that word detail? Yeah, but I felt like we'd had a long discussion about it last time we were here, but yeah, there did.
I'm not aware of an open meetings complaint that has been alleged, reference this term, but again, Austin and I have been on the board about 2 years, which has existed much longer than we have.
I don't remember any discussions on what are detailed minutes or what are not detailed minutes.
Jeffrey Graylow, when I read this,
I read it as implying that the following sentence is a rough idea of what detailed minutes mean, so. So keep detailed minutes of the proceedings, the minutes required in this section must report the results. So that brief description of those minimum requirements to me seems like an attempt to point to what detailed means, is how I'm reading this when I looked at it, so. But I don't know if that lands in the same way, and I have no idea what a judge would think, so.
So we do have kind of a few different things kind of moving all at the same time. It is April. Last year we met in November, very close to the legislative session. Thankfully, AG Jackley was willing to bring our recommendations to the legislator and went over very well. We're sitting here in April. I think maybe maybe this was a discussion we should have had before, is kind of, is this intention of this board is to meet this one time in 2026 and pass legislation on, or what we hope to become legislation in the 2027 legislative session? Or is this the first meeting of a couple or more throughout this year? I mean, because I think that changes whether or not we take a vote on this issue, or is someone wanting to go back and kind of do some drafting and come back to this task force again during the 2026 year?
Austin Hoffman, what I would like to see on this is, before a vote is taken on this, on let's just say number 5, I think it would be beneficial to have a statute drawn up where the public bodies, for reasons of minute taking, are brought under the purview of the Open Meeting Commission without criminal penalties. Be nice to see that statute and have a conversation on that statute in particular before we have a vote on it, I think. Feel free to disagree.
This is David Bordewhite, SDNA, and I would concur with that, the chair as well. I mean, I don't know what the future schedule is, but I would suggest that getting that down on paper and bringing it back for contemplation and further discussion at a later date would be a good thing, given, like I said, we're in the spring of the year and several months before the next legislative session, so there is time there, and I think that would be good.
This is Tracy Kelly. I agree with that. So with that, I'm going to make a motion to table item number 5 to the next meeting. The addition that subsequent proposal will be drafted. Any other public prosecuting.
Okay, we have a motion.
Jeffrey Greenlow, second.
Now we have a second. Any further discussion on tabling number 5? And then with the caveat that we'll have some additional language.
Somebody with a legal background willing to work that into something to discuss at another meeting?
Is that something that, Ms. Scott, you'd be comfortable maybe beginning and then perhaps working with? I'd be willing to look at that language at a later time on a meeting individually with you or a couple of us.
Yep.
Mr. Hoffman and I are both on the Open Meetings Commission, having a meeting.
Want to put it in that draft?
Well, I would say, I mean, and this will be the last thing I say on it. I'm in agreement with what you brought up, Kristen. You know, taking and changing the other laws to add us. Did I get your name wrong?
I said Kirsten Jasper. I just whispered to Beverly, if you want to put me in on it too, that's fine.
Yeah, let's just take those other, let's add open meeting oversight to the other existing laws. Let's create that new law that brings all public bodies into it, completely detaching the criminal aspect of it, and move forward.
And leave 125.3
Alone.
alone.
Okay, we have a motion and we have a second. We've had some discussion. Is there any further discussion?
One thing I was Kirsten Jasper gonna add is we do add in 125, and it might be something that those of you worried about the definition of detailed want to discuss is, I mean, when you look at lines 7 and 8, that is new language, the result of each vote taken by the public body. So whether we want to leave that in and just take out the all public bodies aspect of it, leave the state in there and add in what's in 7 and 8. And potentially even 10. I don't know if that's something that you want to discuss or not, but that to me is a separate conversation than what we have been having. With no opinion, I just wanted to toss it out.
And I think that is a fair, and we have a motion and a second on, really, the motion and second, as I interpret it, is specific to, really line 5 here. As Kirsten just alluded to, there are other additions and redactions as well from, 125.3. Do we want to have a conversation on that or wait and just once we have 125.3 drafted, 3.1, be able to bring all of it back to the table?
Yeah, my motion was to bring this statute proposed back with the change of the public bodies, move that to a different statute, and we would still have a discussion on this. So this would be tabled as well as the new proposal then.
My concern there is if we're gonna table number 5 entirely, technically that discussion should probably be over regarding number 5 in its entirety. So maybe we want to redo that motion a little bit, and I could.
So, and I could make my motion to table number 5 and suggest we have a proposed change that takes public bodies out to just back to the state to the next meeting. And then you're talking a separate motion then to establish new proposed.
Maybe I might be confused. My understanding is that you want to still have a discussion on number 5 regarding the language that it would require the state to have minutes where each individual member or the results of each vote taken by a public body and how each individual member voted on any motion on which a roll call is taken. Just the state.
You're talking, Tracy, again, you're talking about that discussion today then. Oh, okay, I'm sorry.
Kirsten Jasper, all I was wanting to highlight is with the motion as it was, I feared that discussion about the other language would end. And I didn't know if that's what people intended with that motion. So I wanted to.
Jeffrey Graylob, and we haven't mentioned lines 10 or 11 yet here, but there were some important concerns about being able to view the minutes at 3 a.m. at, a state office. I remember from the last one. So that language, striking that language there was also, I think, an important change that we don't want to leave on the table.
So I could amend my motion. So I would amend my motion to have a new draft done for 125. Go ahead.
Before we do that, let's move, it sounds like we're making some pretty significant changes. Perhaps a motion to withdraw the original motion would be proper.
I'll make a motion to withdraw my original motion.
Second. Any further discussion on the motion to withdraw? Hearing none, all those in favor? Aye.
Aye.
Any opposed?
Striking that.
All right, that motion to withdraw passes. So now we're back to having a discussion generally reference number 5.
So do we want to make a motion just to strike that language?
And Tracy, again, for clarification, we don't really need a motion.
Yeah, for this
to
one.
do the new proposed one.
But this is new language right here.
At least I don't think.
Yeah, I would
Get
agree.
rid of that language. Get rid of this language that's in the existing law. That would be the only thing we'd have to take a motion on, is to strike that if that is if that's our goal of what's left of this discussion.
Let's do this motion first, and then that should be brought up to everybody.
So the motion withdraw had passed. We're now just back in discussion. At this point, I would entertain a motion or further discussion if someone so inclined.
Jim Urban, I guess if we, from line 5, I think we've kind of decided tentatively to leave it as the state. Because with the creation of 125, 1.31, we're going to be addressing the all public bodies part of it. So if we just leave it the state, shall keep detailed minutes, all the language stays the same, shall, must. Report the results, add that language. And then strike the at all times principal place of business or board of commission as it's been suggested. Would that kind of settle this matter? Basically kind of putting it back to where we started with a law.
That I'm in favor of going back to the state as the original language. And I think I do like having the results of each vote taken by the public body being incorporated in there, because I think, as indicated, it does help provide guidance or I know define what detailed could potentially mean, at least at a minimum standard. And at all times, usually your statutes say at reasonable times or during business hours, or, so I think just striking that's prudent.
Michael Smith, if we're making changes to eliminate shall and move to must, which seems like that's the new thing that we're doing. Line 6, the shall, probably would want to strike that and make that a must. And then to your point though, line 8, this addition of by the public body, we probably want to eliminate because we're just going back to this is
Back
only
to the state.
back to the state. So either completely reducing it, you're just striking it or incorporating the state back into that sentence.
Each vote taken, I mean, that
Exactly.
is enough, I would think Kirsten Jasper.
Striking by the public body in line 8.
Yeah.
Anyone inclined to then at this point make a motion?
This motion, this would be just for number 5 as it's written now, not dealing with, okay.
All right, I'll see if I can get it.
Hold on.
Okay, oh, sorry.
Michael Smith again, line 9, second, the minutes shall, should also probably read the minutes must.
Yep.
Apparently I couldn't say that, I had to circle it
I
on
guess
your
so.
paper.
Sorry, I was gonna give you credit.
I didn't need the credit, clearly.
Okay, I'm gonna try. So, I make a motion that we suggest that section 125.3 be amended to read, the state must keep detailed minutes of the proceedings of all regular or special meetings. The minutes required in this section must report the results of each vote taken and how each individual member voted on any motion on which a roll call vote is taken. The minutes must be available for inspection by the public pursuant to SDCL Chapter 127. A violation of this section is a Class 2 misdemeanor.
Second that. All right, we have a motion and a second on the floor. Any further discussion at this time? None from the room, any online? Okay, hearing none. All in favor indicate by saying aye.
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 Opposed? Motion passes. Then with that, we will move on from number 5 and on to number 7.
Mike, before we do that, do we need to have that second motion about or talk about that new proposal and for a new section to have that be worked on prior to our next meeting?
So Dylan, we kind of talked about that. Tracy, it was right when we were kind of having a couple conversations moving at once. I'm not sure it's necessary. If the intention is going to be to have other meetings during this year, it's work that can be done now with intention of, we're going to have that discussion regarding future meetings after we get through all of these. It sounds like the indication from everybody in this room has been to have another meeting during the 2026 year, hopes to bring this 125.3 subsection 1 back into light. So I'm not sure it's necessary. If other people disagree with that, we absolutely could. But I'll open that up.
This is Tracy. I don't think it's necessary. I think there's a, kind of a general consensus to go ahead and draft that, and then we would, have to take formal action.
Sounds good. Just wanted to make sure we didn't miss something.
Thank you, Dylan. It's 6 minutes after 11. We've been going for about an hour. Are we having lunch here again today?
Yes.
So intention will be to probably break at about noon. A couple people from the room have gotten up. Maybe we'll just kind of recess here for about 5 minutes, and then we'll begin again with number 7 with the intention to get through at least that before we break for lunch.
Talking here a minute ago. So
I think you have a room full of more than just one.
Well, it was convenient when I don't have to broadcast my ignorance.
He's back now, you don't have to.
To be fair.
I'm good with it. I've been doing it for 50-some years.
To be fair, there is no ignorance. There's just the ability to educate, and lawyers need educated just as much as they're, so.
Tell you right now, any lawyer that tells you they know everything, do not trust them one bit.
Just, I was I had this question and then, on number 7, and I don't know if it's be a big topic for discussion, but if a vote takes place.
Let's, since we are recessed, let's just wait until we get back.
Okay.
Yeah.
Well, this is just more of a legal thing is if a body spends money without it being a legal
To be
action.
fair, if we want to have the discussion, it should be with everybody, because right now you've got a quorum in the room, and so in theory, that is a discussion, and so it should be. We should have it in the actual session, so that we are within our
We are a task
Operating
force that,
standards.
subject to open meeting. laws. Be extra careful.
And 2 of our members will have to decline to be involved in that
Hey, it
complaint.
still leaves an odd number on the board then at least, so.
That's right. Maybe.
I've been enjoying those, county commissioner meetings on the data center.
Actually, it's all the city.
Oh, is it?
Other side of things.
Okay.
We've all city limits. So I've gotten plenty of questions about it.
Good question. I don't know. Why?
Is it because of the size of Sioux Falls that they have the voting authority on that? Or
That's
that's
only
only
guy.
I mean, the state,
Have
the
that.
state one is usually
Yeah,
about,
authority.
but I bet you have to be
The
state
dual
employee to
county.
get access to that, so
The
I
county
don't
commission
know.
dealt
Do
with
you
it.
know if
Their
there's a
side of things
Wi-Fi
is
that's
the county jurisdiction.
It's,
For the data center.
Lydia, line.
Is that?
Okay.
It doesn't, it's not locked, Bill.
Yeah, that's fun.
6 months prior.
If you have any computers, I should be a little bit careful about clicking on random unlocked web. I feel so safe.
I had a couple of phone calls from legislators on that, how I felt about it, and I'm like, oh, you don't wanna know. Just kind of stay neutral on it.
The complex issue.
Oh, definitely.
Sure.
I had one taxpayer come up to me though, and, in one breath, they were complaining about their property taxes, and the next breath, they were saying that, we
You
don't,
gotta have a.
we don't need any data centers or wind farms or solar farms, and I'm like, well, can't have services that aren't funded.
It was literally in the moment.
You gotta pay your property taxes or allow development. And
It's not built here, it's built elsewhere.
Otherwise required. Other proceedings is otherwise required by law. If not required by law.
I think in some aspect though, I think that's more of a scare tactic than it is a reality, because we're not gonna allow sensitive data to be stored.
I mean,
I mean, we just wouldn't be using that resource.
Towns, I get your acronym.
Yeah, SDATAT.
So you guys,
I think part of it is,
as the Seneco folks, or?
go off of Trump's popularity.
Because I don't have enough staff,
Having gold
I do a lot of things.
Yeah.
And when I have time to consult and visit with Chris, we come to a lot of the same meetings. I get invited to their annual meeting, they get invited to ours.
Yeah.
I try to introduce ourselves into some of their legislative discussions and topics and things like that. So yeah, Chris and I would.
However, there.
To us,
It's just say, okay, fine, we're gonna let you go. to the data center.
It's, one of my hats is, chair of the Southeast District, and we're always looking for a good
I know,
speaker.
I've.
You know, we're, Southeast District has got, 32 of the legislators represent some portion of our legislature down there, and, we have quarterly meetings, always have a nice lunch.
I went and looked,
You know,
I kinda laughed
and,
because
visit with the
Water
water commissioners from Southeastern South Dakota and share some of the ways that, we can, chip advising, should be implemented.
I'd be happy to do that. And actually, our board president is here.
Yeah.
Well,
Okay.
just-
So,
Oh, awesome.
Yeah.
Maybe he'd want to come down.
The data center, it's just everybody's coming.
because I do have him, just because geographically, sometimes that's a haul for me to take an
We
evening.
don't see the element.
And then, try to get back to here.
And
But,
then
Yeah.
I would just say.
yeah, we've done some clay union
Yeah.
meetings combined.
But at the same time, though, I listened to Nick, from Live Digital.
Turner, possibly with that. But yeah, I try to periodically.
Oh, and as far as water usage.
Try to create more administrative minimum. That requires my board
That's
to
how
also
it comes in, but a lot easier.
kind of be involved.
Yeah, the water usage
Things
is still
to organize and
significant.
plan some of those things.
I.
And really what needs to happen, because otherwise I get spread pretty thin. Trying to run around to 60 some counties, it doesn't.
You know, I mean, maybe townships can't pull off quarterly ones, but if they can do an annual district meeting or something,
Yeah.
I found
That's what I want to do.
our district meetings.
Geographic.
You have
It's
to
just so
required.
helpful to pull your head up
Minimum.
out of your specific situation and see how are things playing out in your neighboring county, and we get so many good ideas and things we should be watching out for, and, it's just, yeah, it's.
Okay, we may have taken a little more than 5 minutes. Okay, then at this time, I'm gonna call the meeting back to order. We just worked through number 5, agenda item number 5. We're gonna move on now to, well, it's agenda item number 4A. We now move on to agenda item 4B, which was table number 7 from our previous meeting. Beverly, would you be willing to just kind of go over number 7 at this time?
Okay, thank you, Beverly Cox. The, number 7, which is 4B, is a suggested new section that reads, official action by any public body must be preceded by a motion and a vote of the members of the public body present and voting. And I highlighted if you wanted to add the label of class 2 misdemeanor, because the LRC asks, is there a crime penalty that you want attached to each one of these? Thank you.
Okay, so this was again tabled from our previous meeting in November. With that, is there, and I don't recall specifically now, the reason why we tabled this. Anyone in this room have a recollection of that?
Never ran out of time.
That may have been what it was. Oh,
Yeah, I think that was it.
say that, I don't recall having a long conversation about it. So to open the meeting, discussion at this time. Anyone in the room or online have any thoughts on 4B, which is number 7?
Gary Sutton, it just struck me as odd because Robert's Rule of Order, I don't know, does not most entities follow that process? It just seemed odd to see this as something we actually put into law.
Yeah, Beverly Cox, I don't see that Robert's Rule of Law is forced by any law at all. It's just traditionally.
Austin Hoffman here. So again, this is something that came up in the Open Meetings Commission. From what I recall, as Beverly said, there is nothing saying that Robert's Rules of Order have to be followed. There's also nothing in statute saying there has to be a motion and a second. It's just always been understood that that's how you're supposed to do it, more or less. So this is really just a way to get that in statute, saying this is how it needs to be done, not how it should, or not some guidance on maybe how to do things. Ultimately, that, there needs to be a motion. I also think that, as Mr. Kaufman mentioned beforehand, I think a second should be included in there as well. Official action by any public body must be preceded by a motion, comma, a second, comma, and vote of the members of the public body present and voting. So, yeah, there is nothing requiring technically that right now in statute. I think it'd be probably good to have that in there.
Jeffrey Greenlow, one thing that I've noticed in my time with the commission is how many things really seem to be enforced primarily by civil civil law, the rules around what we do as a commission, and frequently if we didn't do the right thing, it's just, the penalty, at least somebody might come and sue us about it. And so I think that based on that, the violation of the class 2 misdemeanor language doesn't seem all that important to me. It seems like simply having this definition in there and then having that be a clear evidentiary line somebody could point to and say they didn't do an official action because they didn't do these things would be, the realistic way that something like this would be enforced. And so I like your idea of adding that language about a second, and I would feel very comfortable leaving off the violation as a section, to class 2 misdemeanor.
Michael Smith, I had a discussion with Kellen Willard, who's not present here, but he represents the city of Delphouche. He brought up the similar, and actually, really for that exact same reason, he actually proposed, he was against this, saying that that's a civil issue, that if there isn't, if they don't follow procedure and if there's official action and the board takes action on what they perceived as official action and someone doesn't believe that that occurred, there's already a way to deal with that within civil law. I think that there's some truth in that as well. And to your point, I do wonder sometimes as we're sitting here creating some new laws, how much work we're putting on state's attorneys, additional work by adding these new sections. But at the same point, there's been issues within the commission where we've had, like Mr. Hoffman discussed in the last one, where we had really no jurisdiction on an issue that we probably should have. And so trying to balance small town states attorneys, part-time or full-time, which already has a demanding load on them from their criminal work and their work with the commission in other areas of its counties, and now adding more potential claims of violations of open meeting laws certainly is a concern of mine. But I like the idea of this, adding this generally, just because it does clarify what's required. I mean, I think the only other way you can go about doing this is essentially mandating like Robert's rules on all boards. But even that could be, perhaps that's more challenging than this keeps it more simple than that.
Carla Engel, I was just gonna comment that under Roberts, there are some things that don't require a second. But I actually think this makes it much simpler and clearer that every motion requires a vote. So I don't necessarily have an objection to that. I just thought I'd point it out.
One language that I think maybe Mayor may not be missing here is at an official meeting. Typically we shouldn't be spending money. We shouldn't be making rules and laws unless it's been posted that we're going to discuss them and have those discussions at an official meeting.
Austin Hoffman, so official action can only be taken at an official meeting. So that would be part of that, I guess you could say.
Yeah, I believe 125 is a good job.
Okay.
Requiring the official action on be made at an official meeting. Mr. Kaufman also made a point as to, who would be responsible here. And I think a lot of the discussion has already been about potential striking this being a violation of the class 2 misdemeanor. But we received a complaint, this was probably a year ago, 18 months ago on the Open Meetings Commission from a state's attorney. And I remember correctly, that state's attorney had done some digging, and his research had indicated that there has never been anyone charged with a class 2 misdemeanor under 125. And I think a lot of the reason for that is, to Mr. Kaufman's point, was who's responsible. If there are other areas within 125 where I think the same can very easily be said. And we're not necessarily discussing that here inside of number 7, but it seems like we've already had this discussion in the table in number 5 as well about the criminal liability and just adding it back into the jurisdiction of the Open Meetings Commission. And it seems like that at least has been discussed here on number 7 as well, as striking the class 2 misdemeanor language and just bringing the purview of the Open Meetings Commission. Perhaps that's a discussion for later, or a broader discussion on whether or not we want to continue having class 2 misdemeanor language inside of 125 at all.
Jeffrey Greenlow, I will just as a reminder, some of the public comment from the last meeting really is pointing in the other direction. And so I do think that there'd be a little public blowback if we were removing penalties unless we have a really good explanation of why. So.
Kirsten Jasper. My problem with some of these penalties is, are you charging the whole board or are you just charging one person? And that seems, to me, the idea is to get people that are actually going to volunteer and follow the rules to volunteer and follow the rules. If you're gonna put a penalty in place and nobody gets penalized, people aren't even gonna care. But if you at least put it in with the purview of a commission that's gonna look at it and take it seriously, to me, that's more teeth than putting in an empty class 2 misdemeanor. And you're gonna get more people willing to volunteer. And if they're willing to volunteer, typically they're more willing to actually follow and comply with the law. But typically.
Yeah, very well. Thank you. I think that's a really good point. Yeah.
Tracy Kelly, and I do have, board members, I always have that discussion, who do you charge? And that I do, when I do call for my investigations, a lot of times board members are really nervous about that. So it is something that even though they've never been charged with, it's something that they do pay attention to, and it's kind of a good tool, can threaten them with or whatever, but is there any discussion about with the Open Meeting Commission putting more teeth with you guys as far as establishing fines and things like that?
Austin Hoffman, we've had those discussions, whether it be amongst the board at a meeting or individually outside of meetings as well. That's a tough one to crack. It really is. When you look at fines, I think the thought is probably in the right direction, but at the same time, are you then going to force a commissioner to pay that fine out of their personal, out of their back pocket? Or is that fine going to the county? And then it's taxpayer money that you're ultimately taking there. So to be very honest, I would like to see some more teeth given to the Open Meetings Commission. Because in some instances, there has been some stuff that's come in front of us that I would like to come down with a little bit of a harder hammer on. But we don't have the ability to do that. I mean, the most we have, the worst thing we can do is put on a piece of paper that our board agrees that you shouldn't have done that. Now, what's nice about that is it does give some clarification on how to do things properly and correct the next time. But should everything have a criminal penalty behind it? No, because in a lot of instances, it's simply a board that misunderstood or didn't remember or whatever it may be. And there's not criminal penalty is not the right tool to use there. But I also think that in some instances where it's just a blatant violation and somebody said, I don't care, this is how I'm going to do it because it's how I want to do it, to heck with whatever these stupid state statute things say. It would be nice to have a little bit of a heavier fist there, but that's a real fine line to walk as well. And I'm not sure what the right answer is how to do that.
Michael Smith, I share with that. In my experience being on the commission, the reprimand, regardless of if the violation is through ignorance or from a malicious act, they all end in the same reprimand. And that does not feel fair because there are a lot of violations that are just clearly based off of ignorance. Oftentimes small boards, volunteers, people who don't do this every day, road districts. We've had road districts, we've had sanitary districts, we've had small county commissions, third-class municipalities. Those violations feel drastically different than those that come in that you can see all sorts of malicious behavior on, but they all end the same way, which is a public reprimand. So I share with Mr. Hoffman that I'd like to see a change. I just don't know how to affect that change necessarily.
Kirsten Jasper, have we thought about, and I haven't looked to see what authority there is within each subdivision, is how I'll say that, but what about removal or a ban from public service for any state, or I don't know, but that was one of the questions I had is fine removal. I didn't like the fine idea for the reasons submitted. but maybe removal from office. I don't know, for a 2-year period or something graduated based on how intentional the commission thinks it is. With a right to a hearing, maybe. I don't know.
Austin Hoffman, I think in that case, you're looking at constitutional rights that come into play. I don't think the board should be kind of judge, jury, and executioner on that one when it comes to somebody's right to serve in public office. Now, as far as county commissioners go, if a commissioner sitting on my board does something that I see as egregious enough, I have the right to file a complaint in circuit court where that commissioner has the right to a hearing in front of a judge, and the judge makes a decision whether or not they should be removed or not. That due process is still there. So I wouldn't necessarily be a huge fan of that, of giving the Open Meetings Commission the ability to do that. But I mean, if there'd be a process set up where it would, could the Open Meetings Commission have the ability to file that complaint in front of a judge,
And
so.
That was we have to create a hearing opportunity for it. Would it be that the commission can file a complaint and the hearing goes? My thought is it might be more palatable is the word I'm going to use for the commission to do it than the state's attorney to have to do it, because if it goes sideways, the state's attorney still has to work with that commissioner. And that can sour the relationship, whereas the commission is still sitting in a commission hat. It could potentially give the state's attorney another option when they're looking at, I don't know if this is criminal enough or whatever, and give another option that still has a result that could make things come in line as they should be. I don't know. Just literally Kirsten spitballing in the corner like she likes to do.
So, Jeffrey Graylow, I think one of the things that comes to mind for me is that I've evolved in my understanding of what the value of the commission is. Initially, I was expecting that it was going to be a punitive body that was, finding bad guys and I don't know, penalizing them. But once I've read more of the findings that have come out, I now look at it primarily as an educational body. And that what you've shared about how it is challenging sometimes to get people to serve in these roles, and a lot of times people are not trained and they are trying to figure out their way through. And I found now the open meetings findings to be some of the best roadmaps to stuff that I never would have thought of. So I just see a lot of value in the current process for most cases, but I don't know, when I'm reading them, I don't feel like I'm primarily reading stories that feel like they have malicious intent at their core. I'm reading stories of people being a little careless, of people being sometimes a little lazy, and then often just not having clarity in process. And then because there wasn't clarity in process, things kind of happened the easy way or something, and those didn't work out well. So I just wanted to share that's been my evolving perspective on the value of the commission. So
I would concur. This is Dave Bordewijk. I would concur with that as well. I recall when Attorney General Larry Long had a task force focused on open meetings laws back when he was in office, and what came out of that was the Open Meetings Commission was one of the proposals, and the idea of creating a public reprimand as the penalty to come forth from the Open Meetings Commission. And I remember Attorney General Long often saying, a public reprimand is having that splashed on the front page of the local newspaper that a board or a commission member was reprimanded was as equally as valuable as a Class 2 misdemeanor in many respects. And so I think it has been proved very valuable over time. But I also concur with Mr. Hoffman in terms of, I think the time has come when we do need to be looking at perhaps some other opportunity or a way to penalize those intentional violations of the law. Maybe it's something along the lines of where the commission could require training under the open meetings law beyond just a public reprimand. I mean, I don't know what the answer is, because it is a tough one to crack, and I don't know where the solution lies, but I do think it's worth exploring and talking about further.
Carla Engel, are you seeing, in those cases where you have a sense that there was a malicious or an intentional violation of the open meetings laws, are you seeing, that repeated after you issued a public reprimand?
Michael Smith, I haven't. Again, we've both only been on the board 2 years. I'm not sure digging back historically if that's been true. In my experience, no.
Austin Hoffman, I would agree with that. Off the top of my head, I can only think of one board that has been in front of the Open Meetings Commission more than once. To be very honest, I think that was more of a political thing than an actual legitimate. It was a legitimate complaint, but there was more political discourse behind it than anything else, put it that way. So I haven't seen one come back again.
Jeffrey Gridley, were you thinking about possibly having the value of having maybe a penalty that would kick in not on the first violation, but on a second or
Well,
third
I'm
or something?
actually thinking that maybe public reprimands work.
Okay, very good.
That's kind of what I'm thinking.
No.
Tracy Kelly, back to number 7. I support putting something in place because it's hard. I would like to see us mandate like Robert's rules unless a board has adopted some other course of conduct, but I think that gets too muddy and can get us in the weeds too much. So I think it is important to maybe start putting some of these things in place that, and I think this is a simple one. If they're going to take official action, it requires these steps. And so I'm in favor of that. I would be in favor of eliminating the class 2 misdemeanor aspect of the statute.
Michael Smith, official action, I don't believe is defined.
It's not statute, just an official meetings.
And that's what I was gonna ask is kind of where we intend on kind of plugging this in.
It's in 125.2 right now at the very end. It's in Jasper where it's talking about executive or closed meetings. And it just says, however, any official action, the only time those two words occur together within 25, concerning the matters pursuant to this section shall be made in an open official meeting. So any official action that you've discussed in executive session has to occur within an open meeting. So it does not specify what official action is within the course. I had already looked at that, was going to comment on it, but now I don't need to.
Yes, Carla Engel, and kind of piggybacking on what Kirsten said, I think earlier there was a comment in response to what Jim said that, official actions are already required to be taken in an open meeting, but I couldn't find anything in the chapter that actually says that, except as to items discussed in executive session.
Tracy Kelly, so maybe what we need to do is just change it to say official action must be taken at an official meeting by any public body and must be preceded by.
Sorry, Jim.
Still think we need to define an official action. Just from a township perspective, there's things that we do that are, what's the term you use? Administrative, yeah. It's.
That actually is addressed,
It isn't.
It is.
Yeah,
the administrative and ministerial, because I know you and I had spoken about that. I apologize, Jim.
Yep, no, that's fine.
But I did notice that if it is incorporated into this language.
Yeah, I found that this morning, but
Yeah.
it does leave some question as to what is an official action. For us, yeah, getting a culvert signed or something,
Right.
that's
And-
administrative, but
It-
there's other boards that we're talking about here too, that I don't understand their roles, that we may be creating issues by using language that isn't defined.
Now I get your question from earlier. Correct, 125.1, Michael Smith, second to last paragraph reads if a quorum of townships is what it starts with. It's kind of the carve out for townships specifically. So I think maybe a couple moving pieces here is if we enact legislation similar to what's in number 7, is that out of line with what is already carved out in 125.1 for townships? And then 2, right, we're using this term official action, which we've only defined once. Do we need to either incorporate the term official action as a definition and scatter it throughout, or is there a better way to go about doing this?
we just define it in the definitions, pages 12, official action includes when there is a motion and a second. I mean, we can define it.
Right.
And then once it's defined, if you've done something other than that, it's not official action, I suppose. Kirsten Jasper, I don't know that I said that.
Are you okay with?
Well, I mean, I know where we're covered from a township perspective, but like I said, I'm also thinking, school board, fire boards and so on. We've got a carve out to protect us, but there, like I said, there's other things, hey, fire truck's down. Are we gonna wait till we can have a meeting posted to get the fire truck fixed? Doesn't sound like a good plan.
We're not, I can tell you that right now.
Exactly. There's things that you just have to do that aren't official action, but they apply to these other boards, water districts, well pumps down, sanitary districts, lift pumps down.
And maybe that does need to be then incorporated into this,
Carve out.
into this piece.
I mean, they don't necessarily create imminent life or safety threats. They could, so they don't necessarily fall underneath an emergency clause, but they're maintenance issues that need to be addressed in a timely fashion.
Carla Engel, so I have a question about that, Jim, if I may.
Go ahead.
So, when you do those things, those emergency repairs, things of that nature, then is that reported at the next meeting?
Well,
Or are those costs approved through some official action?
typically, yeah, you'll get a bill for Jim Urban. You'll get a bill and you'll have to approve it. And then usually if anybody asks, somebody wasn't present at the last call or whatever, what's this for? What happened? And then there's some discussion and, oh yeah, we had to fix that. There's some instances there where there's some hurt feelings or something. It wasn't before a bigger group because maybe it was the method of repair or replace or so on that leads to further discussion. But I mean, it does end up in the minutes typically to make it an official action after the fact. But,
Here's the gesture. So it's not occurring at an official meeting, a meeting that's held pursuant to 125.
correct.
So if we define official action to be something that occurs in a meeting held pursuant to 125, that narrows what official action is. It's at that hearing, but it exempts out just by its language what you're talking about. Is that fair?
Yeah.
And then then your approval after the fact is within the official meeting and becomes the official action.
Does that from a legal, Jim Urban, is that from a legal standpoint, then they'll open us to a challenge? We're spending money outside of an official meeting or an official action. That would be my concern.
But we do have law that does support townships to take action for emergency situations and then convene at the next public meeting
So.
to record what
Role
constituted the
public
emergency.
bodies or, non-excluded public bodies, some way to give these smaller organizations that don't have the resources that a county or a state would have, that are already operating on a budget outside of.
And then Kirsten Jasper, I think if we're defining official action, and the way I just said is anything that occurs at an official meeting pursuant to the law, you've already got your very specific carve out in 125.1, and the more specific law is gonna cover that instance than the more general law, which is what I'm suggesting. Anybody can challenge, every attorney will tell you this, anybody can challenge you for any reason at any time. Whether it's successful, that's where sometimes the craps game is played, right? It's how the dice are rolled.
I just didn't know if we were creating a greater likelihood by changing that, so.
Tracy, by trying to define it more, in my opinion, creates more problems. So, because you already have authority under statute, all of you to do, your administrative things, a lot of things, and then, expenditures of money, whether it's a county highway department that is fixing equipment or doing things. And so we don't want to open a door where we get in the weeds of how much of those things have to come before a commission or a township or something in advance for approval and official action when it's you're blessing it when you approve the vouchers or things of those nature. So I think if we try to create too much of a definition, I think we're creating more of a problem. And I think the more general, and I like Kirsten's ideas, because I think keeping it more general, it makes it easier for those township boards. And as an attorney, it makes it easier to argue. So.
Live in the gray.
That my comment wasn't recorded, right?
Okay, any further discussion? Is someone inclined to make a motion at this juncture?
Just to add in here, Austin Hoffman, I did a quick search to see if the South Dakota Supreme Court had really given any direction on what is or isn't official action. There's only one case out there where it's really kind of the crux of the argument, and it's not what I was looking for. So, I mean, I think it's really comes down, honestly, just common sense. What is an official action?
Here's Jasper. Austin, did you happen to look to see if there's any AG opinions on that?
Sure. There's 3 of them, but it just talks, let me pull them up here. There is one from 1981, meeting at which individual is authorized by Board of Regents to make tentative offer if employee is not an official action. And where by conference call, a discussion was held, the consensus of the board was determined and no official action was taken. There was nothing illegal about the procedure except that in keeping the spirit of the open meeting law, such a discussion should be treated as a meeting with notice. So again, doesn't really define board members participating in a meeting by telephone or not present. So this is going to be 1988. This is old. This would not be the case any longer. So I'm not even going to read that one. That's just going to add more confusion because our laws have changed since then. You are present by telephone or video conference now. That's it.
We have some suggested change in the language for this then, adding in an official meeting.
Kirsten, Jasper, I think what I had suggested maybe, but I don't know that I even remember it at this point, was official action by any public body is action during an official meeting and is preceded by a motion and a second and a vote of the members of the body present and voting. I did not write that down, so hopefully somebody else did.
Can you try to repeat it one more time?
Okay.
Jeffrey Graylow, I was gonna suggest in there possibly official action by any public body must occur in an open meeting. I think maybe saying that.
Oh,
the
I like
action
that.
has to be
This
inside
was
of an open meeting.
already better than my.
No, it's collaborative. That's what we're here
It
for.
should read an official meeting. That is defined.
Yeah. So was it official action taken by a public body?
In any official meeting?
Must occur at an official meeting.
Oh, official action by any public body must. I'm trying to keep up over here with Melissa so that so we don't get ahead of her again, sorry. Must occur in an official meeting
An official meeting.
and be preceded by.
A motion, a second. Oh yeah, you got the second on there, and a vote of members. And then striking the violation of the section as a class 2 misdemeanor. Is that?
Sure, we're not using flogging there.
Jason Jasper's is about to flog me very clearly on the record.
Or a feather for this one.
All right, so it looks like there's some language that's been incorporated. Is at this time, is anyone inclined to make a motion regarding this
I'll make
language?
a motion to.
And would that include the violation language or removing it?
Include with the striking of the violation.
And so as it reads official action. I just want to make sure that this is your motion. How number 7 now reads is official action by any public body must occur in an official meeting and be preceded by a motion, second, and vote of the members of the public body present and voting.
Yes.
We have a motion on the floor to that effect.
I'll second.
I have a second. Any further discussion?
I just have a cool idea, general comment, about the violation section. I can see the business of that. It does seem a little counterintuitive to have to add a criminal penalty if it's hasn't been enforced in the past and most likely won't in the future. But I would say, given the fact that every other provision in open meeting laws has misdemeanor language, it might be wise to keep it congruent throughout by having the misdemeanor language. And kind of going back to conversation with Mr. Hoffman, perhaps down the road this body can entertain a conversation about removing penalties altogether, and or on the other hand, adding stiffer reprimands to be used by the Open Meetings Commission.
Mr. Jefffer, I'm just going to kindly disagree. I think my experience of watching the legislation, when you're introducing bills such as this, they can be killed very quickly if they don't think a penalty is necessary. But if they think a penalty is necessary, they're more likely to amend a bill to add it in if they think it's necessary. So I would rather, my preference, we leave it without the penalty in this instance. And if the legislature in their process decides to add a penalty, I think we're more likely to get this passed in that way. And that's just Kirsten's pure speculation on said things.
Tracy, and I think we do need to remember too, and I understand what you're saying, and I would like to see at least some additional teeth with the Open Meetings Commission at some point, but I think we do have to remember there are civil consequences that whether somebody can certainly.
And I think that as this is now written, I think it strengthens the hand of the public in those instances, which is
And any further discussion from anybody online? Hearing none, we do have a motion and a second. All those in favor signify by saying aye.
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 Opposed? All right, motion passes. At this time, I've gotten a sticky note that lunch is ready. So we'll break for lunch. It's 11:50 right now. Some of us have lots of drive times ahead of us, so is an hour enough? I think we broke for an hour last time. We might have did a little less than an hour because we were behind.
I think you did less.
And lunch is ready for us here. Would everyone be okay coming back at 12:30, about 40 minutes from now? Your seats, head shakes, everybody online. The intention then is to be back here at 12:30 to move forward with the rest of the agenda. And with that, we in recess.
Back over there, can you do us a favor and like the Zoom a little bit on there so that I
wasn't sure. I've got the mic live again, here in Pier. Is everybody on? Signify that you can hear us, please. Office. We can hear you. Okay, great. Then before we get moving in, it is 12:33, so a couple minutes after we said we were gonna come back. Before we get going, Beverly, would you please just do roll call one more time, and then we'll continue with the agenda.
Absolutely. Michael Smith,
Present.
Austin Hoffman,
Present.
Carla Engel,
Present.
Kirsten Jasper,
Present.
Tracy Kelly,
Present.
Dylan Kirchmeyer.
Here.
Hit that one more time. Dylan Kirchmeyer.
Present.
Thank you. Dave Bordwick.
Present.
Willard. Shane Rock.
Present.
Garrett Bishop. One more time. Garrett Bishop. Okay, he said here on your screen. Thank you. Jeffrey Graylow.
Here.
Cole Heisey.
Present.
Kellen Willard. Absent. Terry Slutton.
Present.
Jim Urban.
Present. Thank you. We're gonna just continue down the agenda now. We've worked through 4A and 4B. We need to get through C, D, and E. So we'll start with 4C, which is noted as number 8. And Beverly, would you give us a quick synopsis of what we're seeing?
Item number 8 for the proposed new law is the state shall make an audio recording of every public meeting and retain the audio recording for a period of blank years. All first-class municipalities, as well as any county commission in a county with a population exceeding 5,000, as determined by the most recent federal census, shall make an audio recording of all regular and special meetings and retain that recording for a period of blank year.
Thank you. I'll open this up to the floor. This was a new, this was not anything that was on our agenda that when we met in November. These last 3 items are all new, if you would, to this. This one, I don't know who came up with this idea. I think this was actually generated through the discussion that we had in November. So this language comes through the discussion we had in November. That seems like everybody's in agreement with that. Beverly and I had a meeting, and I proposed this idea of the conversations I've had with folks since that meeting in November. I've seen and heard a lot of concerns from boards, township boards, road district boards, who have some concerns about having the same mandate on the recording as, you know, in County, Clay County, the state, larger boards. So the idea came, this language in the second paragraph was conversation that we had, Beverly and I had, with Kellen Willard, who was unable to attend, just as an idea, just trying to get the ball rolling on maybe putting, if we're going to implement this on, not on every public body, but on a threshold, you know, where should that level, where should that line be if we're going to mandate recordings? Is it on everybody? And if it's not on everybody, where should that be? So the idea came from all first-class municipalities by law are 5,000, towns with 5,000 or more, which is why the language of 5,000 for county populations also was incorporated. I don't have it directly in front of me here, but I did a quick search. I think that means about half of the counties in South Dakota would be required with this language to keep it. Generally, you know, any of your smaller municipalities wouldn't have that obligation, neither do any of your smaller counties, and it also does not mandate this on other public bodies that have concerns about the cost of recording and also, you know, sure that it's done. So I'll open it up. Really, that was just the idea, was just to try to get a line drawn in the sand and see what the task force thought about this proposed language. Agreeable, or it's not to modify it.
Is there anything Terry Sutton. Is there anything within the records retention and instruction schedule that identifies or would give anything pertaining to a length of time that one could use?
Beverly, I think we had that discussion, didn't we? About retention. I think it's civil.
No, it's not as long as you would think, but I don't know if there'd be anything for this.
Just trying to quick look through it and it doesn't give me anything to kind of.
Jim Urban, just, you know, the next thing we're gonna discuss is relating to 180 days for a complaint to be found, so I would say at a minimum, 180 days it should be kept. I know it says years in there, but minimum of 0.5 years would be a starting spot for me.
Austin Hoffman. I would like to see a little bit longer. And there's, I mean, we've had complaint, you know, the investigation process isn't always as quick as one would like. And if somebody is at a meeting, you know, it's a month later and they've got something bugging them that they think was wrong, they finally make the complaint, and then all of a sudden they realize they haven't handed the complaint into the state's attorney and it's 2 months later. It doesn't take all that long. We're all busy. We all know that 6 months is the snap of a finger in our personal lives. It's also very simple to store this stuff. You throw it on a computer, you throw it on an external hard drive, or if you have some kind of cloud storage, you know, unless you're up against a wall with storage space, it can be kept there indefinitely without any effort really at all. So I would like to see a period of 3 years, just more safe than sorry. Leave it there. You know, I've been state's attorney in McPherson for over a decade, almost over a decade now, pushing a decade. And I have yet to get rid of any of I still got all my files sitting. Now that's going to have to change pretty soon here because stuff's getting full. But as far as digital goes, I don't necessarily understand, you know, why we have to have a shorter time frame on it when it's very easy. And that also gives plenty of time. The only thing I would think of that would be corresponding is if there's a statute of limitations for a civil lawsuit against the commission, which might be 2 years off the top of my head is what I'm thinking. So maybe we go 2 years. Whatever the statute, if there is a statute of limitations for civil lawsuits from the public against the commission, that's probably the length of time we need to go with.
Tracy, I thought was along the same line that your civil statute of limitations is going to be longer, so I think we need to look at that as far as the years. And I'm not guaranteeing it, but I'm thinking it's 2 years as well, but that's something we okay. So I think we need to keep it at least that long.
Jeffrey Graylow, my initial take on this was that anything under 5 years was probably not going to be super burdensome to anybody in this modern world. I think that we're moving pretty rapidly towards a place where most people that are on these boards would be able to record them easily. Storage is pretty affordable. So I think that 3 years seems very reasonable to me.
Tracy again, and correct me if there's, I think, a lot of limitations like for records, like just general attorney practice. Like, is it 7 years?
That's kind of the
It's kind of a standard,
Yeah.
right? That's what.
This is Terry Sletton again. In looking the way that language is written, it's like, for instance, in this case, retain 4 years, then destroy, provided all litigation claims and audit findings involving the records have been resolved and final action has been taken. That's one way the language is written.
probably good to include.
This is Dave Bordewhite. Question about any consideration as to executive sessions. I mean, I assume, are we Are those recorded as well or not, or excluded?
This Austin Hoffman, my take here is that executive session would not be recorded. I mean, that's kind of the entire, my personal view on that. That's the whole point of executive session, is to have the private conversations that are laid out in statute that should remain private. You get a recording in there and that changes things immensely, and I think is going to probably steer us down a road we don't want to go down, especially with employee issues.
Jeffrey, go on, Dave.
So Dave Bordewick again. Well, I hear what you're saying, Mr. Hoffman. I would suggest that perhaps maybe some clarification that would need to be put into this draft regarding that.
Yeah,
Just
Jeffrey, great. To that point, I think that when I read in the first line, every public meeting, so that once you go into executive session, you're in a sense in a private meeting for that period of portion of the meeting. But then, if that is how we're going to clarify, and maybe that's not what that's intended to say, but then later they say all regular and special meetings. So our executive session is a portion certainly of our regular meeting. So we might need to clarify that, the second paragraph a little bit. It does seem to indicate that you should also be recording the executive session as it's written right now.
Austin Hoffman, I think a really easy way just to state that is add one sentence at the end of this thing that just says executive sessions are not.
Are exempt.
Yeah, yes, yep.
I did find actually in the records retention and destruction schedule that does identify audio, video recording of board meetings. And they're only going 90 days, so that probably, I don't know how one addresses that, but that's once the law would pass, this would probably be updated then to reflect that.
Need to be, yeah.
It's just in the records retention and description schedule, and it's LG-11.
If this goes forward, just make a note
Yeah.
that that have to be something up like that.
LRC might pick that out too. They should.
Is there any, Jim Urban, is there anything outside of, just wanting to read the minutes, financial matters that would be reviewed later down the road that would set a longer time limit on when it would be prudent to keep these documents or reporting rather?
I mean, Jeffrey Graylow, I could see value in keeping these records in perpetuity from a historical perspective. I mean, we've got a historical commission that would love to be able to go and listen into a meeting from 1975 if something like that existed. So, I mean, there's value there. It's just, I think, balancing it with the burden that it's placing on the bodies. When you get into a really long time frame, from talking to some archivists, I got down a rabbit hole one day. Digital records, we think of them as more permanent and easier to retain, but she was saying, hold on to if you're going to digitize some film, hold on to that film, because that we'll always be able to look at that film, and the digital file formats change, and you might have to keep around old computers that you can plug in and in order to read this file type or something. So that's just something I think that if we stretch it out 20 years or 30 years or something like that, then you start getting into other technical challenges that would be hard for people.
Jim Urban, and I was asking any financial audits that might come down the road from the state, how far back can they go if they find something that, a bid law might have been noted in the minutes of a meeting that they would get called out on if they don't have documentation, the actual advertisements, or just things like that the value of review would offer to any type of investigations. Is that, can they go back 5 years, 7 years? How long would those potentially be of value for that purpose?
Jeffrey Graylow, I would say that I think that because those have been such known issues for so long, I feel like our minute taking has been, and our current record keeping has had more care to try to address those specific kinds of issues. So when I look at this edition, I'm primarily looking for all the stuff that comes between the lines in a minutes. When you write the minutes up, you've got the kind of the high points, and you would have things like, these are what the bid amounts were that were open and things. But then there's all this other discussion that occurs in a meeting that doesn't get captured in minutes. And so I think that when I see the value in this proposal, it is for the public to be able to get back in and say, okay, well, who are the voices in the room and what were the arguments people were making, and get beyond this question of what the outcome of the decision was. Is that addressed? I don't know if that addresses what you're concerned.
I'm looking for use, not potential use or whatever. Practical use being for, like I said, any type of financial investigation.
Jasper, if they're not doing it now, it's not gonna, right? If they're not recording it, providing it now, it's not gonna change, except give them an additional opportunity if they so want. I don't know that. The purposes that you're raising it.
Okay.
The concern is how I'll say that, for the length of time.
You want to put a time limit on it, procedure.
You're still, Jasper, if you don't put a time limit on it, you're gonna have people deciding probably either not to get rid of it, or, which is fine, or to get rid of it sooner than you would like it to be.
I agree. Michael Smith, and I think, number 9 kind of coincides well with this, and it's already been alluded to, essentially creating a statute of limitations for complaints. We certainly need to ensure that the recordings are being kept at least to that number if we are inclined to adopt number 9 as is, or some variety of it. I think the bigger question is whether or not, how long to extend it. If we're inclined to want to mandate 8 recordings, and then if so, putting a time frame on it, what time frame makes sense. And I think for all the reasons that has been discussed in this room, a lot of good ideas as far as trying to be in alignment with what else is required. Obviously, 90 days, that record retention, 90 days is concerning.
Line 6 and line 10 suggestion, put a minimum preceding the word period. That would then allow them to, whatever we decide on, say 3 years, 5 years, 7 years, by inserting that word minimum allows them to keep it longer for historical purposes if they so choose.
I'm gonna look up one statute of limitations here real quick.
Well, you do that. Can we also make big changes from shalls to musts again, like 5 and
I actually looked that one up yesterday. Shall versus must.
I missed that discussion. Sorry, this is Tracy at the last, trying to listen online. What's the move from shall to must?
That was LRC that did that going into this
It was-
legislative session.
Yeah.
Well, they've been doing it for a while. Or one of sometimes it's must to shall, sometimes it's shall to must, and to be fair, I don't know what the current one is.
So not this last legislative session, but the one before that, there was a statute that went through that said it
Yes.
should be must and not shall, which they mean the same thing, but
And then there was
it's,
a statute last year put in place that says shall means must.
and must means shall, yeah, so it,
Okay.
So
Yeah.
they have LRC has, Kirsten Jasper, LRC has a style manual. They like to follow the style manual so that stylistically the statutes eventually become the same style, but
Gary Slatton, what is a reasonable amount of time that one would want to draw up all of the old meeting events to find a historical perspective on why something was decided that is affecting where you're taking that direction today? What's a reasonable time frame? And for instance, I will go through legislative archives, which is different because I want to understand where was the position, originally taken on this particular law that's attempting to be changed. If we take it from that perspective, what's reasonable to research from a county commissioner perspective?
Jeffrey Graylow, my mind keeps coming back to about like a 3 to 5 year range. I think something like that feels like it gives it a long enough window that most of the issues that we're looking at or want some perspective on, if we can get back to 5 years, is enough to get a good picture of how you ran up to where you are today. And all these bodies we're talking about are bodies that'll be in existence in perpetuity probably. So, a 3 to 5 year timeline isn't that long scale of the county.
They can't be downloaded by a historical society.
Right.
Save them for their own records.
Yep.
Off of requirement for the governing body.
That's just my perspective.
Do you want to put a number on it?
Well, hold on here 1 second. Not finding what I know I need to find. 15-2-13, there it is.
Speaking as another county commissioner, I've gone back in the past and reviewed footage and audio, and it's been incredibly helpful. Like, I think that 3 to 5 year range is a good starting point.
Austin Hoffman, so I think the longest statute of limitations that we could possibly be looking at are contractual. And under 15-2-13, that's a 6-year statute of limitation.
We have a lot of contractual matters on the
Right.
commission, so I wouldn't be opposed to a 6-year, to align with that.
Like you said, sometimes
Right.
you want a little bit beyond what the minimum.
Definitely. You have it pulled up and then I'm not going to. Is it 6 years from the implementation of the statute or 6 years from knowledge of the? You like how now I get into I was gonna give the it depends answer earlier and decided that it was a little too on point.
Oh, this one is, so it's 6 years from the date of breach. So if you have a contract, that's a 10-year contract, technically speaking, you could have a breach on the last day of that contract, and you're looking at 6 years past it.
I think does that apply to both local government and state?
Yeah, that's just contractual. So, and yeah, I mean, any contract anybody's entered into. Now, there may be, is there a statute out there limiting that for governmental entities? There probably
Well, there's
is.
statutes, here's the Jennifer, I mean, there's statutes that if you're planning to sue the state, you have to meet certain requirements
Right.
that are much, much shorter than that.
Yep.
DOT construction contracts. It's much
Yep.
But felonies generally are 7 years. So do we want to go a little bit longer than 6 years because of that?
My recommendation is 7 years, so that's kind of a general, generally known.
Shows up in law in other places.
Yep.
And it doesn't mean people can't keep them longer, but and a lot of times entities do just because they're not, unless there's a need to shore up space or, well, in this case with clouds and different things, that might create a problem, but.
Michael Smith, if we're comfortable only applying this to first-class municipalities, first-class municipalities and counties that exceed 5,000 people, I don't believe that 7 years is too burdensome on those boards. Now, if we want to have a conversation about including other political subdivisions, then I think that 7-year when look back, we may need to have a discussion on that 7 years, but otherwise I agree with you. I think that 7 years is reasonable and shows up all over the place in law.
Jeffrey Greenwell, that sounds reasonable to me too. And I also think that, my take on addressing this right now and targeting as we're targeting it is that history continues to happen. And so I could see something like this being a good first step. And that as technologies evolve, people's facility with them evolves, cheap storage evolves, that this would be maybe broadened when in a few years, when we have more of an expectation that it's not going to be burdensome to townships and things. So, yeah.
Well, I think we mentioned asking the wrong question here regarding statute of limitations, because as far as I can see, the current retention laws don't have any relation to the statute of limitations. So when we're looking at this, do we really need to create that relation or make the number of years commensurate with statute of limitations? But the law currently isn't designed that way or written that way.
Can I speak to that? This is Tracy. So, I agree that the retention laws, but I think because these boards represent taxpayers, I think we also need to put in some cushion and err on the side of caution for the taxpayers to kind of preserve their evidence, because that may be their best evidence going forward in a court of law. And if we're allowing them to destroy that within 6 months, I just think it's a good practice.
both sides of the equation could benefit from.
Absolutely.
Any further discussion?
Full idea, one additional question probably should be asked. Are school boards included within first class municipalities, or would they be included in this at all?
They're not under the way this is currently drafted.
No.
The state, city and county correct.
You're missing a lot of bodies with the current draft. Jeffrey Graylow, missing water boards, missing.
Austin Hoffman, and I think we have to have two discussions. The first one we're having right now is the number of years. The second one, which I want to have a discussion on as well, is what boards are we or are we not including? Now, after that, we may have to go back and revisit the first one. So
Garrett Bischoff, I got a question. Are you going to include video recordings as an audio recording, or do we need to modify that and say audio or video? I know our city commission, they do video recordings now and have those available, and our school board does as well. But are you going to make them make a separate audio recording, or will a video recording qualify?
Well, my interpretation of what's before us right now is that if you have a video recording and the audio is on, everybody's not muted, then you have met the requirement of an audio recording. So a video recording, as we consider them, is probably most of the time going to be a video and an audio recording that happen to be covered at the same time.
They're just exceeding the scope of.
Right. That's how I read it, at least.
So I think Austin brings up a good point that there's two discussions here. Maybe we're gonna have to circle back to the first one. Maybe we should kind of move the discussion then into thoughts on the bodies that this law should apply to.
Austin Hoffman. I think I was the one that originally brought this up at the last meeting. I was on Zoom. I don't think I was at the beginning of the meeting. I had court that morning. But it's something I've been thinking about for a while, that this should be a requirement, at least for audio. I think forcing video brings in a whole new ballgame with more expensive technology and is frankly unnecessary, but if they want to do it, they certainly can. A lot of the complaints that the board sees are your smaller counties, our school board. And they wouldn't be included in this the way it's written. Now, I can understand not all small schools maybe would have to be required to do this, but I think there should be some kind of a limit there where at least most school boards are. From a personal perspective, I think all counties should be required to audio record meetings. I don't see the differentiation why people living in a county bigger than 5,000 people, how their tax dollars are somehow more important than people living in a county of less than 5,000 people. I mean, if that's what we're coming down, and the ultimate, my view on a lot of this is that the ultimate goal here is to protect the citizens that live in that certain area, whatever the board is that has jurisdiction over. And 99% of the time, it's going to come down to tax dollars being spent. I mean, that's where political arguments, one way or another, always seem to fall back to, and understandably so. If that's where we're going, I think all counties should probably be required to audio record those meetings.
Tracy, I agree with Austin, Mike, because that was kind of my question, is why did we land on the exceeding 5,000? I think all counties should be required. And likewise municipalities, or at least even including second class municipalities, because again, you're looking at up to almost 5,000 people. I don't deal with the smaller municipalities that are under 500 people, but so that would be my suggestion. At a minimum, we include second class and we include all counties.
Jeffrey Gray a little bit, the risk of losing some commissioner friends. I think that as I'm thinking about this and imagining expanding it out to like the smallest counties that are struggling the hardest to, get their stuff together for their official meetings and keep all their ducks in a row. I do think that this is a pretty light requirement in 2026. And that, and a public body that is charged with all the responsibilities the county commission is charged with, that isn't capable of figuring out how to audio record a meeting in 2026, that might be a sign that there's some other like really serious process things that they need to get up to speed on, because I think that indicates a level of inefficiency and kind of refusal to grow with the times that is problematic in its own right, and isn't something that we necessarily need to like build a statue around protecting. So hope that I said that gracefully enough, whoever's listening out there.
Michael Smith, that we definitely just threw this on here as a starting point so that we could have this conversation. Would it be appropriate to carve out municipalities? And if so, should we also carve out populations for counties? The reason the 5,000 was put on there is because that is the number of a first-class municipality. So I had all of the hope that this would be a discussion piece. We also, though, since that November meeting, I've had discussions again with folks involved with townships specifically who have some real concerns, again, about that also being required of township boards throughout the county, the state 900 townships. So if we were going to delineate, is it just all counties and all cities, municipalities? Then you think of those third-class municipalities of 100 people and the struggles that they have are probably just as sincere as a township would have. So I don't think anybody by any means was set on that number. We just wanted to have that for a discussion piece.
Jim Urban, what is the breakdown population wise for municipalities? Class A, Class B, or Class 1, Class 2?
Cole, I have it pulled up right here. First class is 5,000 people or more. Second class is 500 to 4,999. Third class is fewer than 500.
Michael Smith, I did just a quick review of Jones County appears to have 1,004 people, according to this website that I found. That is the smallest population in the state as far as county population.
How much was it?
1,004. And there are 2, 3, 4, 5, 6, 7, 8. There's 9 with less than 2,000. So I don't know if anybody here comes from a county relatively that size, but I'd be interested to know what the thought process of somebody in these very small counties would be as the implementation of this law on their boards. Is it maybe they have no concerns at all, or maybe it's the same amount of concerns the township would have? I just don't have knowledge.
Austin Hoffman. So I think for townships, in my eyes, there is a concern there. And looking at it comparatively to a county, looking at, let's use election stuff, for example. All the counties have to be hooked up to the state system to register voters. There has to be a computer there. There has to be an infrastructure that is working and usable. Same thing for license plates, registering vehicles. That is all something that can be done at county courthouses. That infrastructure is there. They have to have a computer. They have to be able to have some sort of storage facility already. Townships, that's not the case at all. I mean, townships could literally be doing everything on paper if they wanted to and not have a computer being used whatsoever. So I have a hard time requiring townships to do this, but I don't see how it would be an issue for, regardless of the size of whatever county it may be in South Dakota, because they already have to have some kind of a computer network to be able to be used already.
Just briefly. License plate and registration of vehicles. Some of that stuff is provided by the state because they are operating as the state entity. So to a certain degree, there are still some limitations with how they can access certain things that are provided to them. That's all I wanted to say. That no position other than clarification.
Fair point.
And I do, to your point, Austin, I think that's a point well taken as it relates to counties. How about, I think based off of that, it seems favorable to just incorporate all counties. Second class municipalities, we're talking towns of 500 people. Does anybody in the room or online have knowledge as to the workings of a town of 500 or 600 people?
All I was going to add, Jim Urban, spinning off that county thing. Counties typically they operate out of a courthouse. The commissioners have a meeting room. The equipment can be set up and pretty much left set up in a lot of counties. That's they've got a dedicated meeting space. Bigger cities, same thing. The smaller towns, I know some that share they have their town board meetings in the senior citizen center. So you're gonna be opposing, issues, moving the audio equipment in, moving it out, getting it set up, that kind of thing on smaller municipalities where that threshold lies. For simplicity purposes, if you wanted to include the second class ones or second tiers, 500 is a pretty small town. It'd be nice if there was a number between 5,000 and 2,000 that was already classified. But I would say county's not an issue. The towns, it's kind of a, do we have anybody from municipal league on?
This is Dylan Kirkmeyer, not from the municipal league, but I live in a town less than 500 people. And most of the municipalities in my county, aside from the county seat, fall into that category. Most of them don't have a city hall. The city finance officer is reached at wherever their normal place of business is because it's very much a part-time job. Or the city has a board of trustees that manages the city's finances and duties. I think putting that type of requirement on that size of town would be burdensome for a lot of them, at least of that size.
This is Dave Bordewijk. This is a pretty significant step here in terms of a requirement within the open meetings law. I mean, I realize we're in 2026 and the technology's out there, but I agree in terms of for very small communities and their venues that they operate in and so forth, and the technology issues are real. And I think, I mean, I like the concept overall in this proposal, but I think given the step we're taking, I'm comfortable with saying all counties and all first-class municipalities at this point. I think that's reasonable. It hits those government entities that are capable of dealing with this and implementing it. And you go from there. And down the road, maybe some things change. But I think for right now, given how what I view as a pretty significant step here, I think we're probably hitting on the right mark here for who we're addressing.
Austin Hoffman. So I thought I was going to win the contest of who lives in the smallest community, but I think Dylan just took me on that one. Eureka's around 800 people. We've got a city hall. They've got multiple computers. They've got all the storage capacity that would be needed there. That's going to be a second-class municipality. I know this is something they would easily be able to do. The town I live closest to, I'm out on the farm, is a little town called Long Lake, and that's about 30 to 40 people. There's no city hall. They have their meetings in the back of the little restaurant, bar, cafe that's open Thursday, Friday, Saturday night. And if you got to call somebody from the city, you're calling somebody's home phone number or cell phone if you're lucky enough to have it. So I think it would be pretty burdensome for those third-class municipalities under 500 people. There may be some second-class municipalities that it could be an issue for. I see the majority of them easily being able to meet this requirement. Obviously, the larger communities, there's not going to be an issue there. But I also understand and agree that this is a pretty big step in a requirement for any board, and wouldn't be opposed to, for as far as municipalities go, to only requiring it for the third class or first. I'm going the wrong way here. First class municipalities for now.
Graylow, another entity, I think that it does sometimes make some contentious decisions is school boards. Is that something we want to consider? And they are one that I think varies vastly in size. I just, Googled, tried to find out, well, what's the smallest? The smallest seem to be very, very, very small. And you have ones as big as, Sioux Falls. So, how are there any thoughts about including those bodies? And if so, if there's, populations within the school district thresholds we want to consider with that, or?
One thing that I've learned as I've gotten more involved legislatively over the last 5 years is get the law through, fix it later. Sorry, it's been a tough one for me to swallow. but I think if the goal is to add more, let's get the law through. Because, you know, right now you might have municipal league stepping up and saying, you know, we don't want this level of cities involved. And if all of a sudden you go after school boards at the same time, now you've got another lobbying group. So just from getting the law passed, if that's what we're here to do, is to present something that can be carried. Maybe stick with this scope and then expand it later if you think it's working.
That sounds reasonable to me. Yep.
Doing a quick Google search, Michael Smith. Quick Google search, as I see in the 2020 census, we had 15 first-class municipalities. We have just short of 100 second-class municipalities, and then 200 third-class, real close to 200 third-class municipalities. And I think Jim's point's well taken. There's a big gap between the operation of a city of 501 and 4,900. Those are drastically different cities from the functional, you know, from the government perspective, governmental. But a city of 4,000 people has full-time employees. A city of 501 likely has none. So maybe are we missing the mark on designations? We can use something other than first and second class municipalities as well. I just don't know. You know, that just seems to be categorically the easiest we can go.
I agree. I mean, if there was a better mark in between, I think that would be more useful. But when we're talking, sorry, Jim, but talking about towns, I work with probably a third of the towns in South Dakota, and there's some that are by population fairly good sized, and their councils meet in a room, maybe, I don't know, 8 by 15. And to have audio equipment with places for people to step up to microphones and get recorded at those meetings, it's gonna be very difficult. And it's cumbersome. So we kind of want to really, you know, I agree with you. I've seen the meeting room in Eureka, and they got a good one there. But then you think about it, you go over to Leola, and that city of the meeting room there is so tiny. But you know, it would be tough to get a meeting recorded in that room. But we've got multiple people in attendance, and it would just be kind of people climbing over people just because of where they choose to hold these meetings.
So Michael Smith, there are, I mean, actually some of this language that's incorporated in here comes from the federal census language comes from, there's a law in chapter 7 requiring the state's attorney to be responsible for welfare once the population of the county exceeds 15,000. And that was just a number that somebody pulled out and had been implemented. So I don't know if we necessarily need to bind ourselves to first or second class municipalities. We could, if found in other places in law, we could just designate a number pursuant to the last federal census and then just get comfortable with that number.
I know there's Austin Hoffman. I know there's a lot of county statutes like that too, where it's just a number of residents according to the last census, period. So.
Jeffrey Graylobe, that leads me towards thinking something along the lines of like 1,000 to 2,000. I think that, you know, when you get to 2,000, you've got a substantially larger community that's likely to.
Cool idea. I was thinking along the same lines as you would, you're encompassing all second class municipalities going all the way down. A population of 500 is kind of a lot to ask for those communities, but, and, you know, I don't want to be arbitrary, but 2,000 seems to be a good number. I did look up some second class municipalities in South Dakota. Let's give a couple examples here. We've got Del Rapids at just under 4,000, Millbank 3,500, Hartford and Minnehaha County at a little under 3,400. A lot of these communities that are listed here have city halls, they have staff, they have computers, they've got the technology to be able to report and store that information. So I just hate to see cities of this size left out of a lot of your votes.
And Michael Smith, I'm relying on Wikipedia, so don't take this as the gospel. But I see 32 cities that would fall pursuant to the 2020 census at 2,000 people. So it moves us from first class municipalities as 15, moves us down to 32. 32 cities in 2020 had a population of 2,000.
Jim Rubin, I'm looking at the kind of probably the same census rankings, and by the town halls that I'm familiar with, I see when we get down below 1,500, I see that there's more that we're creating a hardship for. Above that, the ones that I'm aware of, not so much. I don't do business with every one of them, obviously, but, a lot of those,
What was the line again, you said?
around 1,500, 2,000 to 1,500, somewhere in there. I mean, there's only a handful of towns and quite a few of those in that 1,500 to 2,000. I'm not familiar with their setup, so. But
It's Tracy, I live, it's Custer, which is, it falls between that 1,500 and 2,000, and they wouldn't have any issue with the requirements, so I would be comfortable with either 1,500 or 2,000. And it helps us capture some of that second class municipality, and I think there's just too much of a hardship on those lower ones. I'm good with going away from just saying first or second.
Okay, any further discussion? Jeffrey Grable, I'm gonna throw this out there, but perfectly happy to walk away from it too. There is a lot of variation in the quality of an audio recording. I say from experience, we just built a new law enforcement center. We also have a commissioner's meeting room. Both are wired for sound, professionally installed. In the commissioner's meeting room, unless somebody is leaning up to their mic like this, then whatever they said is not on the recording. In the new law enforcement center, it's got mics like these. Somebody whispering in the back of the room is on the audio recording. So saying that an audio recording is required does not mean we're going to catch the same level of detail in all setups. I think that turning on a recording on my phone and laying it on a table in a small meeting would be creating an audio recording and actually probably do a decent job. So I don't think you necessarily, I'm not saying you have to invest in a really fancy system or that we need to be really prescriptive in what we're saying needs to be recorded, but I did want to just lift up that audio recordings are not all created equal, so.
to be useful, if we're gonna have public comment periods, those have to be into the microphone as well, so that what they're saying and it gets addressed is part of the record.
And that feels like, Jeffrey Grell, that feels like what I'm hearing is the intent in this. This seems to say the whole meeting needs to be recorded. So I think that, that would be what it, and I could see maybe the Open Meeting Commission says, well, you know what, we only ever hear your auditor talk because the phone's just sitting next to them. So, you guys didn't actually really record your meetings, maybe that's how that gets addressed, but.
Austin Hoffman, and there's gonna be growing pains with this. I know that. I mean, that there's no doubt. You're gonna have one place that uses an iPhone and it's a room twice the size of this. They sit it down and you're getting half the people talking and half of them you're not. It's gonna come before the Open Meetings Commission. We're gonna say, yeah, okay, you met the letter of the law here, sort of, but this isn't gonna cut it. So I think that those things will over time work themselves out as well.
Sounds good.
So we're looking at 7 years and split the difference between 1 and 2,000, 1,500 people for municipalities, all counties.
So do we want to work on drafting that here before we have a formal motion? That seems to have worked the best in this room. We've had a lot, we've been better this go around, last go around, got a bunch of withdrawals. Kind of worked through that originally, but it does seem like if we work on drafting, then hear a motion, if everybody's comfortable with that.
I think those first lines 5 and 6 just add 7 years. Shouldn't be an issue there.
If you flip flop, municipalities and counties in the original language, so all counties as well as municipalities with a population exceeding 1,500 as determined by the most recent federal census must.
Well, okay, let's get a little bit more to have a conversation, I guess, then too. If you're looking at counties, are we talking about, I would like to leave it just at counties? Because then you're
Yes,
looking-
please. Yep. Yeah, that's,
So
I agree with that.
So
Yeah.
should they be
Yep.
included in that top sentence then? The state and counties, South Dakota counties? And then the second paragraph addresses the population base.
Yep. State and counties must make, yes. Yeah, I like
Yeah,
that.
but Michael Smith, I think the point you were making is we have planning and zoning
Yes,
Other boards within the county. that
Yep.
would Also be.
included.
Well, in the language here, it says county commission,
Right.
which would exclude planning and zoning, library.
Yep.
And such.
Which. we should-
Yep.
And Michael Smith again, 125.12 subsection 2 defines political subdivision county. The word county shows up. Lots of other terms do as well, but the word county specifically is in 125.12. So
Is that the definitions?
that's the definition of a
Yep.
political subdivision, and it says any association, authority, board, municipality, commission, council, county, school district. I think for, if we stay consistent and just put the state and counties.
And all counties.
And just for clarification, the definition of county won't include boards or committees underneath the commission.
It would.
Yeah. So like in Minnehaha County, we have a museum board or a number of other boards that are technically public and open, but those need to be reported according to the definition.
And I feel comfortable with that on a county, the scale of Clay County. So I think that if I were living in Minnehaha County, I think I would feel, if I was just a private citizen, and I would desire that as well. I think that as you get to these larger and larger jurisdictions, there's more weight in their decisions, larger budgets, bigger decisions.
Okay, but like we've got an abandoned cemetery. Their meetings need to be recorded as well.
If they're a political subgroup of county by definition, they would be then by this. Which is now where I'm starting to, sorry, Jim Urban again. I'm starting to question where we're going with this now.
Michael Smith, so the term in 125.12, public body is any political subdivision. Public political subdivision is defined as all these different things that include counties, school districts, task forces. You're talking about task force. They do have to be created by statute, ordinance, or resolution, and is vested with the authority to exercise any sovereign power derived from state law. So they have to be created by statute, ordinance, or resolution, and they have to be vested with sovereign power. I think that's the question, is whether or not we're talking about boards that meet that definition.
Your museum board probably would not.
Yeah.
They have sovereign power.
I wouldn't imagine.
If there's,
Created.
Well, there's just defining sovereign power.
yeah,
Sovereign power is power to tax, police action power.
Collect fines.
Yep.
So a library board. It would.
But a taxes, but yeah.
I mean, Austin Hoffman, that's all gonna be, I would assume there's gonna be an ordinance creating that board. There's gotta be, and that's all gonna depend on how the ordinance is put together at the end of the day. So, I mean, I think we're kind of in a good way getting into the weeds here. When I'm thinking of counties, the commission for sure, planning and zoning, and one big one that we have is drainage. I think if we stick to those three for now, we're probably pretty solid. There's obviously a lot more there that counties can do and some do, but I mean, how far down that kind of rabbit hole do we want to go with boards? So in McPherson, we don't have any of those, so
We've also got a public defender's advisory board, I believe it's called. It is technically an open meeting for public, and I don't know if it fits the definition of sovereign, but there are minutes kept and official votes taken on matters. But
Jeffrey Grable,
To me, sovereign power has got some real meaning. So sovereign power means that you can force people to give you money, as taxes or fines. It means that you can make decisions that have the force of law, so that someone has to do something that this public body said they have to do. And so to me, it kind of comes back to that authority through the consent of the governed idea that brings us all together here. And so I think that sovereign power question is the key. If it's just an advisory board that is going to be making a recommendation to a different body, and that body is going to be making the final decision that has that weight of sovereign power, then that's the one that we want the recording on. But I think that even if it seems like kind of a smaller body or not a super important one, I still think that sovereign power is just very important and should be the trigger for requiring the. And so by that, I think that if we just use the term counties as it's defined in 125 elsewhere, it sounds like it will point that these are just applying to those sub-entities of a county that exercise sovereign power. So.
Yeah, I think it'd be safe to say that my concerns don't really have any validity there, but worth bringing up.
Yeah, absolutely.
I still go back, I'm sorry, Jim, we're bringing in. So a library board that can collect fines, they're gonna have to be recording their minutes, audio recordings of their meetings rather.
But are they setting the fine or is the city council setting the fine and they are just I'm gonna use the word administer, but keeping track of, they're the record keeper. It's gonna depend on what created it. And what it
Back to your
was.
favorite place, that gray area.
Correct. That's what it depends.
And then that's gonna be confusing. I mean,
And municipal libraries are not gonna fall under this.
Right.
county.
Have to be a county. And I'm not,
My wife's a county library employee. That's why I asked.
is a county library then? That falls under the county, is that an arm of the county?
Yeah.
Beverly Hills, I had a question once. City of Redfield owns the hospital. I mean, not the city. It's the county.
County.
And so that's the point. Sovereign power, ability to collect money.
And I don't believe the term sovereign is defined in state law.
I think it's gonna end up being really confusing.
So to add
In relation to this law.
Austin Hoffman, to add more confusion here probably. I don't think county and the sovereign power is the same, under the same, I mean, it's part of the definition of political subdivision, but we're not including political subdivision. County is a political subdivision, as well as any local government entity which is created by statute, ordinance, or resolution and is vested with the authority to exercise sovereign power derived from state law. So those are two separate things. Which kind of leads me to believe, I mean, if we're gonna say local government entity, bunch of words in between there, with the authority to exercise sovereign power derived from state law, that is going to include a significant number of boards. Of many which will be very small municipalities, whatever it may be, townships, all of the above. But if we just say county, I think you are then including every single board that is under the purview of county government as well. So I'm leaning in the direction that for now, we should probably specifically specify which county boards we want to require. And after that, the requirement's not there. For now, if we want to add to it later, we absolutely can. Or the legislature can, whatever it may be. But that keeps us out of the weeds and stops this from getting real confusing for people down the road.
Michael Smith, and I think to that point, as I was sitting here trying to figure out how, we're having a hard enough time trying to figure out how to draft this. We are gonna expect all of these smaller counties and everyone in between, from Minnehaha all the way down to Jones County, to understand how to implement it. And we need to be very clear with the language that we're using, so there's not ambiguity to the having state's attorney, the Open Meetings Commission had to do.
Jeffrey Graylow, trying to think back through some of the various entities that you may or may not have in a county. So I think that minimally, I would want the county commission and the planning and zoning commission, if it exists, and the board of adjustment, if it exists.
Yep.
So those are kind of the top three that come to mind for me.
Clay County no longer, Michael Smith we no longer have a drainage board, so I think,
Lucky you.
I believe the counties with drainage board probably would also appreciate that board. We have a ditch board.
But our commission sits in the ditch board. So are there other counties that, there may be other counties that have a ditch board that is separate from the commission?
Can you, Jim Urban, change it to boards governing water rights, water control rights, or you're gonna make it a mess by trying to do this, but, I see what you're saying is if we name it the water board, well, might be a drainage board over here, might be a ditch board over there, it might be, we know what we want it to say, but without coming up with a term that is all encompassing, how do you say it?
Dave Bordewijk here. I would suggest perhaps this is one that maybe needs some more work to come back at a later date to see where we're at. I mean, I think we all agree on where we want to go with this proposal, but I think obviously devil's in the details of some of this. So perhaps we need to spend some more time on that rather than trying to figure that out right now.
It won't. Dave, is that a motion to table?
Yes, I make a motion to table.
Motion in a second. Any further discussion?
Again, my discussion, not that I'm looking to table to do away with, but I think just to allow more time to put some more work in this to come back with the sound proposal that's got some good definition in it and that we're all on board with.
Seek input from the South Dakota Association of County Commissioners to see if they have thoughts on. I think that would be great input. Is there anyone who has connection with the municipal league who would also be willing to reach out to them? Because that might be helpful. Kellen, of course. We'll get Kellen to reach out to the municipal league as well. So that could be valuable. So we don't want to fight this battle and then get to the legislature.
We should hash it all out now so we get everybody behind it. Yep. Okay, we have a motion, we have a second, we've had some discussion, is there any further discussion?
All right, all those in favor of tabling, say aye.
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 All those opposed, indicate by nay. Motion passes.
And then at this point, we will move on to what's designated on the agenda as 4B, which is number 9. And Beverly, would you go over this with us?
Okay, Beverly Cox. This is, in general, an act to require that a complaint be filed with the state's attorney within 180 days. It is a revision of 125.6. If a complaint alleging a violation of this chapter is made, the state's attorney shall take one of the actions. 1, to prosecute. I'm going to shortcut this. 2, determine no merit. 3, send the complaint to the Open Meetings Commission. With the added section, a complaint brought pursuant to this section must be filed with the state's attorney within 180 days after the date of the alleged violation. That's the your digest version.
Thank you. So the intention, I think, behind this ultimately is whether or not if there should be a statute of limitations for complaints going to the open meeting commission. I don't know if I haven't seen it, but I haven't seen one that's egregious, but the concern I hold is that somebody's going to start digging up minutes from 10 years ago or agendas from 10 years ago, and whether or not, that's appropriate. If that's something that we want to entertain, that spending our state's attorneys and investigators' time on the Open Meetings Commission, or should we put in some sort of firm statute of limitations inside of 125?
Like it.
It's great. Yeah, I like it.
Yeah, Dylan Kirkmeyer here. I think 180 days makes a lot of sense. It's still fresh, or at least somewhat fresh in anybody relevant's mind. You get much further out than that. Some of the people on the boards or commissions probably aren't going to remember what they said or what happened anyway. So I think for all parties involved, the complainant and the people that are being accused, I think that 6-month time frame is a good thing.
Kind of de-weaponize the two. Jim Urban, the only thing I'd like to say is line 13, if we're going to be publishing this information, I'd like to see the complaints identified as well as the boards.
So it is, Austin Hoffman, part of that complaint is required to be a signed and notarized complaint. That's part of it. So they are, they're in, if you look through the entirety of the documents, it is in there.
Okay.
If you look at line 6, Michael Smith, look at line 6, that chapter, it's a complaint alleging violation must be made pursuant to 23A21. That's language specific to how to make that complaint.
Yeah, I was just, if the state's attorney's office or the attorney general's office is gonna release it, you know, just make sure all the parties are involved.
I'm gonna make a motion to pass number 9 as proposed.
Second.
We have a motion and a second. Any further discussion?
You only want, I mean, you only want it to be 180 days? Do you want it longer?
No, I don't want, I prefer.
Because what if you don't know, what if your realization doesn't come to fruition until much later?
Then it probably was not a substantial violation. If it didn't impact you until 9 months later, just saying.
Pretty great. Well, I feel like I can imagine instances when you might not note the effect until, I mean, because these are issues with open meetings. So if something was not out in the open. So if it was hidden well enough, it might take you 9 months to find it. I had initially thought maybe a year made more sense, but it sounded like everybody was feeling pretty comfortable with the 6 months. So I wasn't quite to the point of voicing that, but I will say that I had a similar thought. Maybe slightly longer.
And one of my, Kirsten Jasper, lots of questions, not a lot of answers today. We've got after the date of the alleged violation. I mean, to me, sometimes you don't know it's a violation and at that time, similar to when we talk about contracts, right? It's from the breach. It's when the 6-year statute of limitations. So what about knowledge? What about becoming aware? I mean, it waffles the time frame a little. Waffle isn't the right word, but it changes when the time frame starts. Just devil's advocate, sorry.
Cole, I was kind of thinking along the same line. We just had a lot of discussion about how long the auto recordings should be retained. Set that at 7 years. And one of the things we spoke about was having those auto recordings in the event that, there's litigation or, something had to be reviewed. It just passed. And, if we have that information, it's records, but you can only bring something 180 days after the alleged violation. It's not totally connected, but there's a connection there. I think between those two things.
Austin Hoffman, I wouldn't be opposed to going a little bit longer than this. I would say at most a year. The reason, my view on it is if nobody has noticed that there's a violation for a year and all of a sudden that one person sees it, I would question that alleged violation's validity to begin with. So I think it kicks out some of that. It's also is directly correlated to the next point. If you're looking at anything much past a year, it's probably more of political I don't like you than anything else. Why is it taking a year to bring something up that was alleged misconduct according to the open meetings violation? I can see the argument that 180 days is a little short. I very much, I can see that that's a pretty quick time frame. I wouldn't be opposed to going a year, but I think we've got to have some kind of pretty realistic end to being able to bring an action there.
Here's the things I think about, and keep in mind, I don't work for a county, I don't work for a state, but sometimes contracts are bid, but the work doesn't start for a period of time. And so the finance aspect of it becomes a problem. And when you go back and look, you're like, oh crap, this didn't happen. That could be a year down the road. I mean, to me, the financial aspect of it is where, to be fair, I don't know that I have an opinion one way or another, but to me, 180 days, considering how much time we've spent talking about the other things, we flew right past it. And so I just wanted to highlight and start a little bit more discussion. I think I did that because I'm.
Dave Bordewijk here. I would be, I'm sorry, Kirsten.
You go right on ahead.
I apologize. I would be more comfortable with a 1 year time frame than the 180 days.
I'd be more favorable, longer extension to a year, perhaps even longer, but kind of throwing out a hypothetical here, but what if, sometime down the road, it's found that the board didn't properly pass or vote or give the right vote seconds on something, and the validity of that vote or spending or tax or whatnot is brought up at a future date. Are we hamstringing ourselves, with limiting the time frame for complaints?
Austin Hoffman. So if something in that case were to come up, there's still going to be a civil avenue to go back to right that. So I mean, this is only for open meetings violations. If something contractual, if the bid process was done incorrectly, the wrong person got that bid, there's an entirely different time frame that can be looked at to ultimately file the civil lawsuit against the county on that end. But what I'm going to do is make a motion to rescind my previous motion, and we will go from there.
Then, well, I got earlier, but any a second for that? I was in second. Cole Heisey, second. Okay, any discussion on that motion to rescind motion? Hearing none, all those in favor indicate by saying aye.
Aye.
Opposed? Motion passes. So now we're back either at a point where we either have further discussion or someone is inclined to make a new motion. At this point, we could entertain that as well.
Just before you,
Maybe not.
we have some shalls in there.
Ah.
On line 6, make that shall a must.
So here's to Jasper, if we're gonna make this proposal and we go through, have the Attorney General submit it, LRCs can make the changes they wanna make anyway, so I don't know that we have to be that nitpicky now that I think about it a little bit.
Shall must stuff.
For the musty shells, yeah.
There's a term of art.
Dylan Kirkmeyer, I wouldn't, oh, sorry.
Go ahead, Dylan.
I was just gonna say I'd make a motion to change the time frame to 1 year and then pass to recommend.
I'll second what I think I heard you say. Yep.
Get the language up here, make sure we're all on the same page.
All right, Dylan, is what's on your screen in compliance with what your motion intentions were?
Yeah, sorry, my internet might not be great.
That complies with what I thought I seconded. Yep.
Great. We have a motion and a second then, based off of what we're seeing, the language up on the screen. Any further discussion?
It's all brought me around.
All right, hearing no other further discussion, all those in favor indicate by saying aye. Aye.
Aye.
Opposed? Motion passes. We move on to our last item. Now, we have been going here for a while, a little over an hour. We've got one item left. It might take us some time. Perhaps it'd be prudent to just have a quick recess. People to go to the bathroom and we'll be
We can
right back.
stretch our legs. It makes us think better. Yep.
So 5 minutes and we'll be back.
I need to switch off the water here.
It went a little fast for me the last time. I didn't get my thoughts out before there was a motion on the table.
Yeah, close. Keeping the packing tape business alive over there, huh?
It's not working.
That's right.
Is this right off the bat?
Oh, yeah, we need to talk about that.
Provided, I think I sent.
I got, yeah.
I'm gonna send them to Eric.
I want them by,
If you had a chance for it. Yeah.
it's just,
Steve. They're all available.
cause I did that during the breakout sessions last. Only thing I wanted to do was like run through my slides.
Oh, you had.
Yeah, it's just what I put together last time.
Oh, that sounds great.
But at least I just wanted to run through and see, make sure there wasn't like something that I had other than the ones you, or whatever, you know what I mean? Just to compare a little bit, which I could do. What is today? Tuesday, Wednesday, I can do that on Thursday. Yes,
Okay,
and then I'll call you.
that sounds good.
Yep.
And then, what I was thinking to kind of make it sound interesting, I'll take a couple, you take a couple, I'll take a couple, you take a couple, but you can have five, I'll take one, you can have five. Yeah.
Or whatever. I mean, those things I like,
Yeah.
we just go up and talk. I hate trying to plan that stuff out too much. Just do it.
Yeah. So that sounds good.
Okay, yeah, I'll go through that on Thursday, just to see. So, I mean, I've got actually on here, I could email to you, but I'll have time Thursday to look at those. Tomorrow, we'll not have time. I got stuff I gotta do tomorrow, and then I gotta leave early afternoon for Madison.
Okay,
But Thursday I'll have some time to look at that.
sounds good. I'll wait, I'll sit tight.
I was pulling into here this morning. The end of last week, I saw a blurb, can't remember where it was. Disorderly naked male tased multiple times in Aberdeen, finally taken into custody. That was great. Found out this morning that the Long Lake resident, some issues, right? Ready? Sheriff, Yankton. I don't understand. It's just one of those deals.
Yeah, Mr. Conklin brought up some legitimate concerns or criticisms, but okay,
We gotta figure out how to deal with that.
can rebut most of them.
Where's my stuff?
Yeah, I'm definitely looking for one second.
Mm-hmm.
Is Kaufman still on the call?
I thought, I thought I looked on it.
Oh, it is three on there now.
Yeah.
Yes, Gary Kaufman still,
Oh,
Look at that.
very good.
Thank you, Gary.
you're welcome. I'll mute again.
Nope, good. Or email me.
Yeah, yeah.
I'm stopped, so I won't.
Okay. You must be able to hear us, but we just confirm that. I think everybody's present in the room. It's been a few minutes, more than 5, it's closer to 10. Can I get online? Everyone still able to hear us okay?
Yes.
Yep, we're good.
Perfect. All right, then we will move on at this time to the agenda item number 4E, which is designated as number 10. It's the last of the substantive work, if you would, of this body for today's agenda. And I'll ask Beverly to introduce it, but then I believe Mr. Heisey would like to make a statement, and he's the one who ultimately I think is responsible for the drafting of this proposal. So go ahead.
This is Beverly Katz. I'll give an overview of number 10, which is an act to clarify the public comment process. No change in the statute until you get to the paragraph that is being suggested as being deleted. And that states the public body shall reserve at every official meeting a period for public comment limited at the public body's discretion as to time allowed for each topic and the total time allowed for public comment, but not so limited as to provide for no public comment. And then additional language is being proposed that states the public body shall reserve the public an opportunity to comment on each individual agenda item, including any consent agenda considered as a whole, before the public body discusses or takes any action on that specific agenda item. The opportunity for public comment on each item shall occur immediately prior to the body's discussion or action on that item. The public body may establish reasonable time limits on the time allowed for each speaker and on the total time allowed for public comment on each item or for the meeting as a whole, but shall not limit such comment so as to provide for no public comment on any agenda item. The public body shall not discuss or take action on any agenda item until the public has been given the opportunity to comment on that item as required by this subsection. The public body shall not add any new item to the approved agenda after the meeting has begun, unless after the item is added, the public is first given the opportunity to comment on that new item immediately prior to any discussion or action on it. And then it just goes on when public comments are not required. That's the summary.
Cole Heisey, Minnehaha County Commission. I appreciate the chance to speak in support of this amendment. I wrote this a number of weeks ago to address some of the concerns that I've been hearing from citizens across the state. Right now, our statute simply says public body must reserve a period for public comment. It doesn't say when that comment must happen or how it must relate to actual decisions being made. As a result, as may happen in city councils, county commissions, school boards, other public bodies across the state,
schedule a single public comment period at the very end of the meeting after every agenda item is discussed. And in these instances, citizens finally get the microphone. The decisions are already made. Their input comes from frustration instead of participation. It's my view that erodes trust in government. It leaves people feeling shut out of the very process that affects their taxes, their schools, their neighborhoods, and their daily lives. Some public bodies, at times, have taken this vague requirement even further. They have allowed public comment on certain agenda items while deliberately skipping over others, sometimes those that generate the greatest public interest, and voting on them without any opportunity for citizen input. And some public bodies even have it in their policy not to allow comment on agenda items at the closing of the comment section. There have also been instances where items were added to the agenda during the meeting and then acted upon with no opportunity for public comment. This selective pick and choose approach seriously undermines public trust and leaves citizens feeling that important decisions are being made without them. The amendment before you fixes these problems in a straightforward and, in my mind, a common sense way. It replaces the vague somewhere, sometime rule with a clear requirement. And I quote, "The public body shall provide the public an opportunity to comment on each individual agenda item, including any consent agenda considered as a whole, not in part, before the public body discusses or takes any action on a specific agenda item." In short, the comment must occur immediately prior to the board's discussion or vote on that item. That's basically it. Comment happens before the decision, not after. Consent agendas are treated as one item for comment purposes. The public still gets a package before its approval. Public bodies keep full authority to set reasonable time limits, how long each speaker may talk, and the total time allowed for comment on each item or for the whole meeting. The only thing they cannot do is eliminate comment entirely on any agenda item. For those that may be thinking it, this is not an extreme change. It is actually the standard in several other states and the procedure already found amongst most public bodies in South Dakota, including Minnehaha County. As an example, Texas law requires members of the public to be allowed to address the governmental body on an agenda item, and I quote, before or during the body's consideration of the item. California's well-known Brown Act does the same. Louisiana and a number of other states follow similar timing rules, including Florida and Pennsylvania. These are mainstream, practical, open government practices, not radical experiments, and they have not caused issues in those states. Their laws strike the same balance this amendment does, meaningful public participation without stripping boards of their ability to set reasonable time limits. Boards still run their meeting efficiently. The only difference is that citizens are heard when their input can actually matter. For South Dakota, this amendment is a natural fit. We pride ourselves on neighborly, responsive local and state government. Requiring comment before action simply ensures that our public bodies hear from the people they serve at the moment it is most useful, before minds are made up and votes are cast. It strengthens transparency and accountability without adding bureaucracy or taking away any board's ability to manage time. In my mind, this is good government, plain and simple. It restores meeting to public participation while respecting the practical needs of our elected and appointed officials. And I strongly urge the committee to advance this amendment, and happy to have further discussion or answer any questions.
Thank you, Mr. Heisey. And with that, I'll open it to discussion among the task force.
Carla Engel. So I really appreciate you explaining the reasoning behind it, because I will confess that when I read this and also heard Mr. Kaufman's comments, I was thinking, yeah, this is a solution without a problem. And maybe that's because of the way we handle public input on the boards and commissions that I serve on, or that I advise, because public input typically comes at the beginning of the agenda. And so when we have people who say, well, I want to talk about the administrative rule you're going to consider later in the meeting, then the chairman says, oh, well, then I'll allow you time to comment on that when that item comes up on the agenda. And so now that I've heard the reasoning behind it, I'm just wondering if the way to correct this might be something slightly different than what you've proposed. Because I'm a little bit concerned about us having to remember to ask for public comment on every agenda item. But if we did something kind of like what we do with conflicts of interest, where they have to appear at the beginning of the agenda. So I think the law says that conflicts of interest have to be considered immediately after the public body convenes. We did something like that. Then if I want to comment on something on the agenda, I'm going to be able to do that before people act on it. And then it also gives the chair the opportunity to say, you're going to get to talk about that, but why don't we have you talk about that when the item gets presented or, you know, the item comes up on the agenda. So I'm wondering if that's an alternative to what you proposed that might make it a little bit easier, a little bit more streamlined, I guess is where I'm coming.
Cole Hyde here. Actually, when I first started working on this amendment, I started out with the simple idea of requiring a public comment section or a general public comment section at the very start of the meeting, and not necessarily requiring public comment on every single agenda item through the meeting. You know, as I kind of worked through it and worked through different drafts, a lot of different contingencies and situation hypotheticals, and a lot of complaints that I've heard anecdotally from individuals across the state kept coming to my mind, and came to the conclusion it wouldn't entirely fix the problem, especially when it comes to agenda items being added later in the meeting, or not allowing public comment fully fleshed out at the very start, whether it be 10 minutes or what have you. And you know, there are a lot of boards are already doing things very well. I mean, if you look at my side of the state, Minnehaha, Lincoln, some other surrounding counties, it's their standard operating procedure to by default ask for public comment on every single agenda item. And in Minnehaha County, my county, we do that, and we haven't run into any problems that have extended our meetings, beyond that unreasonable amount of time. Discretion is still with the chair's power to choose how much comment is heard on any single agenda item. And, you know, Minnehaha, Lincoln, some other bigger counties there's no end to controversy and, on some matters, and, members of the public coming to those meetings. But, we haven't seen any issues with opening up public comment on every single agenda item. But I do like your idea. It kind of captures the spirit of what I'm proposing here. I just see with that idea, though, we're going to run into the same kind of problems in other public bodies that aren't holding to that down the road. So,
Here, go ahead, please. Kirsten Jasper, and I had a similar idea to Carla. My thought was shall reserve at every official meeting a period for public comment after the agenda is approved. Because then you've got your approved agenda, everybody knows what's going to be talked about, and at that point, then once the agenda is set, then people have the ability to do a public comment period. My concern is putting it as structured as this. I think you lose the ability for a chair to feel like they have discretion. Similar to our last task force meeting where our chair let public comment go on after every opportunity. He allowed public comment. He has checked even today. Anyone online have something to say a number of times because he has the discretion, and it allows him to be more creative in how he's going to do his discretion. And my fear is twofold, that this is going to chill some people wanting to even participate in the public body because they're going to feel like it's going to be super long. Whether it is or it isn't, outside the point, they may feel that way. So they may choose not to participate, by coming and commenting, or they may choose not to be a volunteer in that type of a scenario or take on the duties of even being the president or the chair. And that can cause different problems where I think if we can do some tweaking to what we currently have, where we do move it up, it at least avoids the problems of the ones that are doing it at the end or before the agenda is approved, which I think hits the concerns that you raised. Just Kirsten's thoughts.
I tend to agree. I think that the issues you brought up are valid, and I understand this now a lot better than when I came in here. So thank you. But it could be simplified just by defining when that comment period needs to be in relation to the agenda being approved. And, maybe a little more language as far as allowing more than one opportunity to speak as different agenda items are presented, however, but I don't want to make it to where the law is so encompassing that, like Kirsten said, it intimidates the people that are supposed to be actioning on the law.
Cool idea. Yeah, it's a valid concern. I did bring a couple alternative proposals, and Kristen and I are thinking along the same lines again here. And I wrote something to the effect, and I'll just read it out here. A period of public comment shall occur immediately following approval of the public agenda at the beginning of the meeting. It shall be at least 10 minutes in duration. And we can quibble about the number of minutes. But the real problem I'm trying to solve with this amendment is public bodies skipping over public comment, not only at the beginning, but all through the agenda items, and placing that public comment section at the very end after votes have already been taken and discussion amongst the body has already taken place. So we can work through, some tweaks to this, shorten it, bridge it. I'd be open to that. That's really the essence of the problem that I'm trying to fix with this amendment. And the one that I proposed is an all-encompassing one, and it may be a little bit too far, too quickly, giving the existing law that it's replacing. So I'd be open to compromising on, getting to the matter.
Austin Hoffman, I very much like the idea of having public comment right away at the beginning. I have been on a board that the public comment period was reserved or put at the end of the meeting. I don't like that. It doesn't, to me, it feels like, what's the point then? The public input it doesn't really matter because the votes have been taken, decisions have been made. I don't really see a point in that. So I think having it at the beginning makes a lot of sense. I think it's a little too structured and formal to require it for every single agenda item. I like being able to give the chair some leeway, and I've seen our chair do it at commission meetings where somebody gets up and they start talking about something and he'll say, well, just if you can wait around, just wait till that agenda item and you can talk then. So I very much like that. Now, this isn't, what I'm going to bring up next isn't on our agenda, but it was brought up in some of your concerns, and it's a concern of mine, adding things to the agenda after the agenda has been approved. I don't like that at all. And I think that's something, if we can add to our meeting for next time, that should probably be discussed. The point of an agenda is to get it out there so that people know what's going on. Now, I'm well aware, and we've dealt with it before, that items can be added to the agenda at the beginning of a meeting before the agenda is approved. But I think once that agenda is approved, that should be the agenda for the meeting. I have a very difficult time seeing how it's appropriate midstream to be adding new things to the agenda, really giving no public notice there at all. So I think that's a discussion that needs to be had, but today's probably not the day for that.
My observation would be that you do have public comment prior to things being voted upon, but then at the end, have opportunity for public comment on items that may become a future agenda. So they can be heard initially by the board, given consideration to add to a future agenda. If there are people who want to introduce new thoughts and, ideas.
That, just to address that could be done at the opening public comment is okay. I know it's not on the agenda for this time, but I ask this to be on future, or they can reach out to any board member and have it added to an agenda for a future meeting at any time. I want to kind of back up though, to support what Cole was looking at. If somebody takes the time to come to our meeting and we're not going to hear them until after we've approved our agenda, they don't have the ability to put something on that meeting necessarily that came up in the last 24-hour period since we posted our meeting. If we allow that public comment period, maybe before and after the agenda, or before and then retain the right to have them comment again when an agenda item comes up, that kind of solves both avenues there. It allows the public to be able to add something to the agenda prior to its approval, but then still allows them to be heard on specific items on that agenda.
Okay, sorry, we're going back and forth here. I have just always adopted from the attorney's direction for the association that townships do not act on items that are not on the agenda, because that 24-hour minimum notice posting is not too much to ask to have that identified before. That's why I incorporated that conversation at the very end. So the new thought, new idea that was not posted for one to, determine, they would have missed out because it wasn't posted on that agenda or published if it were the annual meeting.
Sure.
I don't know, just my opinion on that.
I'm not saying take action. I'm saying discuss. I mean, that we can talk about what the concerned citizen brings to us at that meeting. And if it requires action, then we postpone that to a later date, or we, as Michael Matthew pointed out, there's an option there if you want to fight it to go ahead and take action. But I think, for our discussion, we follow our legal advice and postpone the action part of that discussion until later.
So because Kirsten and the devil's advocate, yeah, I'm gonna do a little bit of it. So what I'm hearing, well, and maybe it's the people who were selected to be on this illustrious body, but a lot of really good systems to not do what you're talking about. Minnehaha County doesn't. Clay County's our system. We have visitors to be heard at the open of every meeting. And so anybody, you can bring your banjo and play us a song for 5 minutes, whatever you want. You can say something that you really feel like should be on another agenda. You can come and read a letter about, how important somebody was to you or something like that. Sometimes we have things that are not on the agenda. There's no action there. We just take input. We might decide to put it on a future agenda item. And then when people are in that, oftentimes they think this is my chance to talk about something. And our chair always says, we'll reserve that comment. We're going to have that agenda item and you'll get a chance to speak before that. So that works pretty well for us. So my devil's advocate is this something that should be handled electorally? Is this something where if a chairperson or a body isn't working with a process that works well for their particular jurisdiction and people are feeling not heard, then they take out a petition and they run against them in the next election?
Jim Urban. I tend to agree with that sentiment, but we've just spent the last 4 hours talking about things that could have been handled with that same approach. If you don't like the results, run and take their place. So, I mean, I don't want to punt his concerns to, if you don't like it, take on a petition.
Yeah, I mean, I think these are very valid concerns, and I think that, I would be very upset with my elected body if they're behaving in that way. So, yeah, I'm not saying that that's necessarily that we shouldn't do anything to try to address that here, but I'm just wondering about the various ways that different jurisdictions are addressing this.
I do agree with your sentiment, though, that we shouldn't be dictating every minute of the local meetings. We should leave some flexibility in, but I do like the concept of putting that public comment period where it's actually useful to the board before actions are taken instead of after the fact. I argue, just from my own experience, quite often those votes are usually decided upon largely before they're heard in the public comment period, but at least you do get that opportunity to hear another perspective that maybe you haven't already been presented in your preparation packets and stuff for your meeting.
Michael Smith, and
One of the concerns I have, and I appreciate Mr. Heisey's, you've got some other stuff prepared too, which I appreciate, because one of the concerns I have with the way that this is drafted is that
it creates very strict procedural requirements, which I think could very easily, again, weaponize the Open Meetings Commission by if there's 15 agenda items and you're required to allow public comment before each one and start fail at doing that once. Are we just creating a procedure that's just at what end, at what cost? I think we're all in agreement that, I believe that having a public comment portion at the end of the meeting without having one prior is a waste of time. I would be, like, it needs to take place before, agenda items are ultimately determined. And I believe that I think we've seen that before. I think we've seen where the, agendas have shown public comment at the end of the meeting. I think I've seen that inside of the Open Meetings Commission. That feels like something that we should probably contemplate correcting. I think that at least in part, that's what this is trying to do. And I think that's an absolute net positive. It's just a matter of, figuring out how do you then ensure that the public feels as if they have an opportunity to be heard in an item that impacts them is gonna, is it at the beginning? Is it just discretionary to the chair, allowing it, like Jeffrey stated, our chair does a good job. It usually shows up in Clay County with like ordinance changes, where there'll be, normally there's 2 people that are out there as our visitors. Usually one of them doesn't want to make any comment, the other one does. But then suddenly on a random Tuesday, we have 30 people in the room. And that it's always, do we have any public comment not on an agenda item? Because we'll get to you. But do we need to ensure that that's being done on every board level? Are there boards that are missing the mark on that? And it sounds like there probably are. And is that something that we should be incorporating in language here? I mean, I like the idea. I just wonder if it's possible to do that well enough to eliminate your concerns, which is that, will people just say, throw your hands up and say, I'm not
So
willing to engage?
Jeffrey Grayloaf, so to pose this, so I think that Kirsten did a good job creating, I think, a good minimum standard of after the agenda has been approved, public comment period will be reserved, so before the items are heard. And that could be, then you could interpret that as being as the agenda is running before each item, or, is that, does that provide enough protection in your mind, Cole, to some of the concerns that you're bringing up?
Cole, I think it would be a step in the right direction. Like Mr. Hoffman said, there are boards that meet and they have their meeting and they skip over the agenda items and without any public comment to speak of until the very end of the meeting, which defeats the purpose and the spirit of the existing law as it is. So I think we should at least put a meeting at the very beginning, just so there's at least one required public comment section where people can comment on the agenda items. Now, most boards across the state are following the spirit of the law and are allowing comment on specific agenda items, and especially ones that are of most public interest. And I really wrote this to account for situations in which that's not happening, and those do happen. The only drawback of only requiring public comment at the very start is there may not be enough or sufficient public comment to really satisfy the public interest on any number of agenda items may come later in the meeting. But it would be a step in the right direction nonetheless, by at least requiring that. And Jim, you had brought up having a meeting, if I interpreted you correctly, at the start and at the end as well, or?
No, I wasn't really sitting at the end. I was saying to allow before and after the agenda is finalized.
Oh,
that way the public has the ability to bring a discussion item for today's meeting, as well as if, say, after they've sat down, they've been recognized, somebody else throws another item out there, and then, oh, hey, I have a thought on that as well, so they could still be heard on anything else that got thrown in after they had the opportunity to speak. But at the end of the meeting, I think it's kind of like kissing your aunts goodbye at Christmas. You forget about it real quick.
What about, again, Kirsten Jasper, what about doing something to try and expand a little bit on the after agenda approved idea, which says something, the public body shall reserve at every official meeting a period for public comment after the agenda has been approved, but or something to the effect of, and as later determined necessary, or as later determined, or additionally as determined by at the discretion of the chair, or something where you add after the approval and you get off and you give the chair discretion to do it after that as deemed. appropriate or necessary. I don't like any of those words, but I'm just saying.
So your concern, if I may ask, Carla Engel, is they approve the agenda and then they add another item to the agenda later. And then there's not public comment on that added item.
Cole Heisey, that's one part, or one problem that this amendment would fix, but I say the main thrust of this amendment would be allowing public comment on every single agenda item. There are instances where the public doesn't have the opportunity to individually. A single one, but that's a kind of a secondary concern is when agenda items are added after the approval of the agenda.
Cause I'm kind of where you were, I'm sorry, I forgot your name.
Austin,
Austin.
but I'm calling other people wrong names, so you can call me.
Let's go with Alex for this conversation.
So I'm struggling with the idea of adding agenda items unless it is an emergency item, truly an emergency. I am really struggling with why agenda items would be added that aren't posted.
Jeffrey Graylope, I just want to interject that I think that is absolutely something that this commission should
It's a very
seriously
big
consider.
loophole.
I don't know if it fits within this, was the only reason why I wasn't back on that earlier as well.
Yeah, we have to handle that stuff.
But I definitely agree, Graylope.
Awesome. That's
One thing before we go on, sorry, Garrett put something in the comments and rather than me reading it with my inflections, well, on the terms that I was just gonna call attention so that he has a chance to speak. So sorry, Garrett, put you on hot spot. Maybe. What he said, I mean, I can read it since we can't hear him, but all public bodies must have a policy in place to allow for public comment, leave control with the local bodies, is what he said.
Austin Hoffman, for the most part, I agree with that. Where we are right now is that the statute reads that you have to reserve period of time for public comment. It's at that time, the amount of time for public comment in general, like the whole block of time, is up to the discretion of the chair. How long you want to give individuals to speak individually is also at the discretion of the chair. That's where we are right now. And that's it. That's all that is required. There's no requirement when that public comment is, how long it is, anything like that. For the most part, I think we're seeing the majority of boards realizing that, hey, it's probably in everybody's best interest to let people comment on individual agenda items, but that's not always the case. And there's some discretion there, and I'm okay with that. What I personally have a problem with, and I think that there should be something dictating when it needs to be, is the point in the meeting when that public comment is. To me, public comment is completely irrelevant and not worthwhile at all if it's not until the last 10 minutes of the meeting when everybody's done, all the decisions have been made, and everybody just wants to go home at that point. I also understand that there's times where public comment can be a little heated, and there may be people there telling commissioners or city council men and women that they're not doing a very good job, yada, yada, yada. Well, when you run for public office, that's part of the deal. If everybody in public office up and quit because somebody doesn't like the job that they're doing, we would have nobody in public office. So that if you're not going to have a little bit of thick skin, it's probably not the job for you in the first place. And if you can't get past that first 10 minutes after taking a little bit of heat, maybe think about stepping aside, letting somebody else there who can. Is that maybe some harsh words? Possibly, but I think at the end of the day, we're probably all on the same page here, that we don't want this to turn into something that's too formal, but at the same time, it makes sense to have a period of public comment to be required to be at the beginning of the meeting so that people can voice their opinions to whatever board they're in front of. I mean, I think that's the direction we're all going here, so.
Tracy.
don't think we want to put too much structure on the boards. It's their meeting, and I think that they need to be able to run it the way that they best determine fit, but they do need to have that public input. I can tell you, not to throw my county commission under the bus, their public comment is towards the end of the meeting, which to me seems senseless. And I think, I've heard other public entities or boards sometimes use that as a tool to weed out having, if we put it towards the end, then maybe the public won't be interested in staying and participating in that. And that's not an appropriate use of the public meeting. So I think it is important that we set some structure that requires it up front, because I think that will solve a lot of issues. But I do think there is a problem if we have boards out there that are adding agenda items after the agenda has been approved. I think that's a separate issue that we should look at and address.
Cole, I also added, didn't include it in my statement, but the general public knows when a meeting starts. They don't know when the meeting ends. So, having public comment at the end of the meeting, as some boards do, leaves little to no opportunity for the public to actually attend that meeting, especially if you've got work and kids and other obligations. If you were to set at the very beginning, the public could at least be assured there is a public comment section, and they roughly know when that's going to be held, so they can speak.
So, Michael Smith, we're talking about, of course, having another meeting later this year, in which what Mr. Hoffman presented is bringing another item in, which would be discussing, agenda items specifically and when things can be added, but they can't. Would it be fair to say then that perhaps kind of finalizing what is number 10 and the appropriate language kind of needs to wait until we see that amendment as well? Because otherwise, if we have more clarity on what and when, what is allowed to be added when to an agenda item, perhaps then we'll have better clarity on when public comment should be required. Is that fair?
I think it is clear that we all think it has to be at that time, which is, I think, easy enough to pass legislatively. My question, though, Carla, is you said at the preceding of this discussion, did you say something to the effect of individuals letting the chair know I would like to have opportunity to, have discussion on agenda item 3 or agenda item 6 or something of that nature could be introduced into this in some way?
I think that's part of the public input item. I think if you put the public input item at the beginning of the agenda, then people who come to the table and say, I want to talk about item 5, then the chair has the freedom to say, oh, well, we'll allow you to do that when it comes up on the
Right,
agenda.
and I
Or
think
they
that
can
would be a
accept
good
it
way.
at that time.
I think that would be a good way to handle it. It would be very easy then for time management to know, okay, we only have 1 versus 20 people, and then you could say, we'll have 5 minutes to address, or everybody gets 2 minutes or whatever is needed for time management's sake.
Yeah, I'm uncomfortable with putting, I think there was an
Well,
earlier.
not for us to, incorporate that, but it would give the chair
Yes,
that opportunity for time management
yeah,
and self-regulation.
yeah, I want. the
Declaring to
chair-
everybody, we are going to be out of here by 11 PM or whatever the case is. I mean, it gives the chair opportunity for a lot of discretion.
Yeah, and at least with the way our meetings run, very often an agenda item is introduced by someone who describes what it is you're proposing or what's being proposed to the commission or to the board. And so I think that's important to have the public comment in that context, because sometimes the public doesn't know what it is you're actually planning to do. And so that if they can hear that, sometimes that addresses their concern or it helps refine their comments to know what is actually being proposed. So the other thing that I'm struggling with here is people should be prepared to take a little bit of initiative. If I'm hearing that this agenda item is coming up, why aren't people raising their hands or approaching the table where people? I'm not, I'm not understanding why we have to be so prescriptive in the process. I think there should be some small amount of initiative that's taken by the public when they're hearing items discussed.
Jeffrey Grable, I will say that I have experienced bodies shutting down that initiative. So I have seen that.
That's terrible.
Yeah.
Yeah, Tracy and I would say the same thing. I think it depends on your body and your chairman that's running that meeting and how they're running that meeting. Because we have one that he's very good at during the discussion, even after a motion's made, allowing the public to comment from the audience. But other boards don't take that initiative and take that motion and that discussion as being board only and don't allow the public. So it's very controlled by who your board is and who your chairman is.
Yeah, Cole Heisey, and yeah, we were to implement the amendment as submitted to committee. It wouldn't really affect most boards that are doing things, in my mind, correctly or in the spirit of the existing law. It would take care of situations where that's not being, the spirit of the law is not being followed. And as for the adding of agenda items, I still see that as sort of a separate issue, but technically speaking, it is lawful for a public body, do correct me if I'm wrong, to add an agenda item, during the meeting after the passage of the official agenda, or adding something prior to the passage of the official agenda. This amendment is noting, taking account of that factor, that whole that already exists. So I think we should, like Austin said, handle that at a future date, to a future committee. But for purposes of this, I think we can still either pass the amendment in full or compromise on some language that would require a public body to have public comment at the very beginning. And that by itself also would affect what public bodies they most have public comment section beginning after they pass the agenda. But some don't, and it would be fixing that issue.
Tracy, again, I would just going forward, I would be in favor of modifying it to kind of the version that Kirsten talked about, which is that after the adoption of the agenda, that public comment shall immediately follow that adoption. And then leaving discretion to the chair on agenda items and discussion if the chair wants to allow it at the public comment time or wants to inform them that we'll reserve your comments to the time of the agenda.
Right. Yeah, and this wouldn't restrict, that amendment or that change wouldn't restrict the chair from opening up public comment on individual items further in the meeting. I did write some alternative language, similar to Christian's. I'll read it again here. A period for public comment shall occur immediately following approval of the public agenda at the beginning of the meeting. It shall be at least 10 minutes in duration. We can quibble about the number of minutes, but I think 10 is a good starting point.
Oh, I see. Jim here. I don't like defining the number of minutes. Just from the simple fact, okay, so I start my meeting, I'm 5 minutes in, we get to that point, we've approved the agenda. Somebody walks in 8 minutes later and wants to, we've already moved on because there was nobody there to talk. If we just set it as a public comment period, I think that would suffice without defining what it shall be. Because honestly, if there's people that are looking to use this to silence people, they'll come up with some other way. They'll hide that, they'll hide it somehow.
So simply, simply take out and shall be at least 10 minutes and end it with following approval of the public agenda at the beginning of the meeting.
That's where you want it, yeah.
I mean, under number 10, that first page, lines 18 through 21, which were lined out. I mean, you can really just reword that a little bit and add in a few things, but kind of what I came up with, and it means the same thing. Public body shall, at every official meeting, immediately after the approval of the agenda, reserve a period for public comment. limited at the public body's discretion as to the time allowed for each topic. The rest is the same. But then everything in red on the next page would be removed because that's kind of the really more formal stuff. So really, as far as the statute goes, it would only be amending lines 18 through 21.
Cool, yeah, personally, I'd be open to that change and bringing the original language back with some amendments or changes.
Austin, can you work with Melissa to ensure that the language you are coming up with and just put out to us find its way to the.
Don't forget your shells and musts.
Your musty shells.
That's someplace I signed it up for launch.
Inspect your water vehicle for musty shells.
Yep.
That'll be next legislative session. They'll be defining musty shell.
We can only hope so.
As coined by Kirsten.
That's the legal general consensus, though, that I read yesterday is legislation has to quit using shall and start using must, because must is more demanding or more definitive on you have to do it.
Shall is biblical. That's perfect.
Shall implies that.
Depends on which Bible.
Okay, that's fair. There you go. All right. Thank you.
But isn't
thank
there
you.
case law on shell that says it's obligatory?
Yeah, they said that too.
Yeah.
Everything that AI came back with contradicted itself because I mean went down to.
That's because everything in the law contradicts it. Yeah, I didn't have much of a chance.
My brother's a state electrical inspector. And my favorite thing is, I mean, there's a book this thick of codified laws on electrical. And then the very last paragraph, all blah, blah, blah herein of this book is interpreted by or is open to interpretation by local authority. So just throw the whole book away and let Danny have his way is what the book told me.
I like the septic system rules. If you read their administrative rules, it's like 20 pages and it's super prescriptive and it's got percolation rates and all these. And then the very end, it's like, and as long as you did all this stuff, you don't have to tell anybody about it, seek any permits. You're good.
I'd been
You're like, "Wait a minute."
I'd been installing systems for 3 years before I knew what a percolation test was. Like, oh, okay, let's dig a hole and put water in it.
Okay, so, Mr. Hoffman went over and ensured that the language that he had discussed is now incorporated into lines 18 through 21. Is that correct?
Yes, you can't quite see 21 on the screen.
Yeah.
Not quite.
You can probably close out of the chat and then that'll lengthen it a little. I'm not bossy at all, so sorry. about that.
That's right. Okay, line, what now?
Scroll up just a little, see if we can get.
For you, something changed there from what I have on my, scroll down a little bit, limited at the public body's discretion. Oh yeah, never mind. Okay, yep.
You can kind of see that there's changes on.
Right. And there are no suggested changes that are found below, is that correct?
There would not be. Ultimately, everything, yeah, all the stuff in red would be removed.
So if we can scroll back up to 18, that would be the changes that would be discussing here. There we go, 18 through 20. So I just maybe open it up to the floor again for discussion, or if we have a motion, just to ensure that this was the intention of this body.
Cool, I just want to make sure that as it's written, you can't interpret it as that's the only period of public comment, that the board has the discretion to open up a comment on other items or have a section at the end of the meeting.
I had a similar concern because that's one of the things I was really listening for as we were looking at some prescriptive language is like, I like our system. I don't want to not be able to do it anymore. And all I see is that this is a requirement, but it is not prohibiting anything. So you have to have this period and it's silent on whether you have additional periods. Which I read as we can keep doing things the way we've been doing.
Yeah, right, not gonna be restrictive, yeah.
I can see how it could be used that way.
Yeah.
You could have a chairman say, nope, we heard you at the beginning, we don't have to hear you again, but
Well,
that's,
technically, that is how it is.
that
They
is the
don't-
law.
I mean, they don't have to, you know.
And just to raise this, that could be something that a particular chairman had an agenda item, they wanted to go a certain way, and they could have had a system in place where they were allowing comments at each thing, and then, you know, they could say, well, you know what, we're not having any public comments on this one, I don't want to hear from you 30 people, I know what you're gonna say already. And that is allowed
Right. And
as this is written.
back to what you said earlier, I think that is something that the political process takes care of. If you've got a chairman or somebody on the board that is severely limiting public comment on something else, or picking and choosing, well, get a petition out and run against them. That's what the political process is there.
What if we change it to say, this is Tracy, where you have the public body must at every official meeting immediately after the approval of the agenda, reserve a period for public comment and put a period there. And then go on to say, time allotted for public comment may be limited at the discretion of the public body, period. Public comment period does not prohibit further public comment at the board's discretion during the meeting or something to that effect. Does that, along those lines, help your concerns?
Maybe,
I mean,
yeah.
it could be said better than I said it.
clarity too,
Yeah.
or intent.
Well, I know the main concern, it could be, you know, interpreted in such a way that there's only the public comment at the start and not throughout the entire meeting.
You might run into problems with LRC. Because they don't like language that says, oh, but this doesn't do, you know, whatever. It doesn't affect whatever. So they're gonna view it as not saying it. It's not really directing, you know, or requiring anything. It's just kind of leaving it.
Yeah, and Jeffrey Grillo, so I think that I didn't really mean to express so much a concern. I would agree that I think that gets into a space where electoral politics should weed out that bad chairperson, and this should be an example of bad chairpersonship. And I do think that the what's proposed right there creates a window at the beginning of the meeting after the agenda is approved, and a person should be able to say their piece in that time. Ideally, we should have more robust input than that later, but I think that this solves that kind of narrow problem that we're trying to make sure we address, of just like tacking that on at the end or saying nobody gets to say anything about what we're doing here today. That's my take on it.
Okay, good.
All right, I'll go out on a limb and I'll move as proposed currently, the proposed amendments to 125.1. That's what's on the screen right now.
Jeffrey Grillo also. Yeah, no, you go.
I'll second that.
Right. We have a motion and a second. Any further discussion? Hearing none, all those in favor indicate by saying aye.
Aye.
Those opposed? Motion passes. Right. We made it through, agenda item 4, A through E, and the only thing we got left here is, discussion regarding future meeting or meetings. Do we have any thoughts on that? Now,
I would,
Oh, go ahead.
I would say leave it till fall, but not so late that there isn't time to get stuff through LRC, find people that want to carry it, that kind of stuff.
And I was working through that as well, as I was thinking avoid the summer, perhaps late September, and then if we need to have a third meeting, which we hope we don't, but we were able to get language to in November passed. And I think that was really pushing it. I think September timeframe is nice because it gives us that cushion that if we absolutely needed to meet again before the 27th legislative session, we could, but also aim at letting that be our final meeting, to allow that time to get language to the Attorney General and then out to.
Kirsten, Jasper, I have a question. What's the AG's legislative timeframe for when he likes ideas submitted and through his process? Because I have a feeling it's before September.
I thought
Mr. Beverly, I thought the state agencies have a deadline.
We do.
And
The
I would like-
agencies are I
Yeah.
believe agencies are different than the AGs on the deadline because he has a,
So
as I
we-
recall, it is a different process because he is a constitutional member and
I would feel more comfortable shooting for your same deadline because I don't know offhand.
know our deadline.
So we're usually meeting on legislative items at DOT in
August.
August.
Yeah, we're usually tied up with everything before September 1st.
Yeah.
Okay, that's what we're shooting for board elections. And votes.
So what we're doing is just shooting a hole in that big
Yes.
foot. that you just
That's
put
correct.
out there.
And what I'm also hearing is multiple people in this room are gonna be tied up in late August.
I'm gonna be tied up, I mean, there's always something.
Yeah, I mean,
So,
We turned out 3 pieces of legislation that wasn't talked about until what, November 4th?
yeah, but I'm gonna be real honest, I think we got squeaky clean lucky on that this last time. And I mean,
I wasn't
squeaky
in
clean
favor of
lucky.
that.
I'm not saying leave it till that late, but I don't know that we need to meet again in the summer months.
I don't feel comfortable waiting. I still would rather have something earlier than later. You're right, I didn't know if we were even gonna have somebody to bury it.
I'd be open in August or September. And I mean, the kicker on this year too is there's possibility of a significant amount of changeover and training.
No, no, that can't be.
Everywhere.
I believe, all across every umbrella that we're referring to.
Yes.
Yeah.
Jeffrey Graylow, a couple thoughts that I had is that, so when we had our first meeting in the fall, we were all new to each other, new to the perspectives we were bringing, reviewing things we'd never seen before. We've now got a couple proposals that we've moved. We've got some stuff that's gonna get wood chopped. We might have, I'm kind of hoping that we have another kind of fresh thing come dealing with agendas, but we might be able to do it in person in August, and we might still be able to have a productive kind of cleaning up Zoom meeting, just thinking for scheduling easiness, I mean, maybe we could even get 2 meetings in August where we'd have one and then maybe 2 or 3 weeks later do just kind of a finalizing one of like, those changes that we think we agreed on in the last one, is everybody so good with that or something like that? So maybe just thinking that might be realistic to get things done.
August is generally tough, but the timeframe everybody's comfortable with. What if we aimed for? Phase to breathe, go back to the drawing board a little bit before September 1st.
Just for everybody who learns that is during the, at least on my calendar, the rally week.
I was gonna
Why we
say,
have that on as ours, but sometimes that gets a little bit more problematic for me.
Right.
But,
That's good for me. That's the week I'm not going to the hills, so thank you. Yes.
well, I think it should be the week before, so I don't know why it's on as that week, but that is unless they changed.
Following the Florida thing, I might be in Florida that time, but I can always try to participate by Zoom or
In my head, it should be the 2nd through the,
7th through the 16th.
oh, so it is right. They didn't start it on the first Sunday this time. Okay, so that is rally.
yeah, or we go a week earlier then.
I'm out that week.
Are you?
Before we go, we could,
It would be, it's one of those vacations though, that I wouldn't be so, disappointed that it worked out.
I mean, I don't think there's anything wrong with going the end of August either. I mean, I think that still gives time. Right.
Yeah, 17th would be better for me. I've got stack week for potential felony trial. So I'm 80% chance I'm open that week or 70% chance, but I won't know until July.
Yeah. 18.
Got a commission meeting.
Is anybody opposed to the 17th?
Nope.
Monday? That's easier for me too, especially those who had far travel. Traveling on a Sunday allows me to be more productive during the week than traveling on Monday. Kind of kills 2 days of my week if I travel Monday and travel Tuesday.
Travel Monday or Sunday and then start earlier on Monday and then give more time to be able to get back Monday night.
I'd be okay with that. I mean, but I know there are plenty of people in this room though that choose to have a 2-3 hour drive that prefer to wake up early and drive.
Yeah, I mean, I got like a 2.5 hour drive here and I don't, I'll leave that morning and if I gotta leave at 5:30, I really don't care. I don't sleep with a darn anyway, so
There shouldn't be an issue.
no.
It's 2 of us. What if we tentatively plan the 17th at 9 a.m.? Anybody online have anything they'd like to add as to the schedule of the next meeting? Okay. Hearing none, and I believe now we have our next meeting scheduled. We get that out to everybody. Okay. Scheduled. If that needs to change, we will obviously get back to the drawing board. But that's the last item on the agenda. I would entertain a motion to adjourn.
So move. Second.
Those in favor?
Aye.
Motion passes. We're adjourned.
Love you.